我今天几万的，这会儿有几万的，我不是贵的时代，我还光那还不是贵的时代给你，哎呦，这个，这都是了的啊，
On 30.
Next Thursday.
Yes, this Thursday.
Okay.
30. My lord, again, I'd like to mention item number 53. Oh, yes, on behalf of Libica, my lord. Kindly list the matter after 3 weeks, my lord.
On behalf of
Libica.
Mr.
Also
Sunil, Garden
this.
Council, on behalf of Mr. Viveka, Garden Government Advocate. Any objection?
Objection.
With consent from the other side, as for listing the matter on when?
After 3 weeks, my lord.
After 3 weeks. There.
My lord, again,
Is there any interest?
no, my lord.
No.
My lord, again, I'd like to mention item number 11. On behalf of Libica, my lord. Kindly list the matter after 2 weeks.
Who
Yes,
is
ma'am.
for the petitioner? You inform the other side?
Yes, my lord.
Same order?
After 2 weeks, ma'am.
After 2 weeks.
Much
Yes.
obliged.
Yes.
I would like to pick item number 8 and 9, behalf of VZ Momi.
10 and 9.
Yes, Lordship. 8 and 9.
8 and 9.
After 1 week, Lordship.
Your good name?
Ajumle, behalf of VZ Momi.
Appearing on behalf of Mr. B. Zimomi, Garden Council. For the
Lordship.
Zimomi is for the
Government, state.
state government with consent from the other side. First of listing the matter after
1 week, Lordship.
1.
Lordship, there's an interim. Interim.
Interim.
Yes,
Okay, till then interim order first order shall continue.
By this, your lordship, I beg to mention item number 61 and 62. I plead this matter may be listed after 2 weeks.
You obtain consent from the other side?
Yes, your lordship.
With consent from the other side, Mr. Your good name?
Benison Visual.
Garden Council. For the petitioner, based on listing the matter after
2 weeks.
2 weeks. Yeah.
Obliged. May I please, my lord. I beg to mention hearing item 56, lordship. If it can kindly come up after the winter break, lordship, because a similar matter is pending before the division bench. I do the appeal on the same issue.
You from the other side?
Yes, Lord.
Mr. Santi Anger, Garden Council. For the petitioner, based on listing the matter after
The winter vacation,
vacation.
yes, my lord.
There.
Highly obliged.
Your Lordship, I beg to mention item number 16.
1/6.
Yes, Your Lordship, 1/6. Your Lordship, state is yet to file affidavit, so kindly grant 3 weeks time.
Your good name?
AIME.
Garden Council for the state respondent. With consent, you obtain consent from the other side?
Yes, Your Lordship.
With consent from the other side, based on listing the matter after 3 weeks. By state to file affidavit in opposition.
Yes, Your Lordship.
Here,
Your Lordship, similar prayer for item number 18 and 19. State is yet to file affidavit, so kindly grant 3 weeks time.
you obtain consent from the other side?
Yes,
You inform the other side?
Your Lordship, they are present.
Objection of.
No objection. Yes. Same order.
Your Lordship, item number 20 on behalf of Inauli, kindly grant 3 weeks to file affidavit.
Same order.
Yes, Your Lordship. Your Lordship, item number 31.
Yes.
Here also state is yet to file affidavit, so kindly grant me 3 weeks time.
Okay.
No objections, my lord.
Okay. Same order.
Your Lordship, item number 32 also, on behalf of Livika, kindly grant 3 weeks time to file affidavit.
From the other side? You from the other side, madam?
No, Your Lordship, not yet.
Will be proper to grant judgment in absence of the other side.
Your Lordship, petitioners are not
Yes.
present.
Same order.
Your Lordship, item number 43,
Yes.
on behalf of Inaoli, 3 weeks' time may be granted to file affidavit. Your Lordship, item number 29,
Yes.
3 weeks may be granted to file affidavit on behalf of Livica.
Okay.
Lordship, item number 44 also, on behalf of Livica, kindly grant 3 weeks' time to file affidavit. Item number 30, on behalf of Inaoli, 3 weeks may be granted to file affidavit.
Inaoli.
Yes, Your Lordship. Your Lordship, item number 25 also, state is yet to file affidavit. So kindly grant 3 weeks' time.
Your Lordship, there is interim.
Interim orders and conditions.
So, Your Lordship, item number 22 and 23 also, similar prayer. State is yet to file affidavit.
Yes, Your Lordship.
Yeah.
Lordship, I pray that this may be the last chance, Lordship. This matter has been filed since last year,
Which
Lordship.
matter you are at 22 or
22 and 23, Lordship.
both?
Yes, Lordship.
Stateless mobile is the last one so file. Is there any interim?
Oh, no, Lordship.
Your Lordship, item number 14 and 15 also, state is yet to file affidavit. So kindly grant 3 weeks' time.
No objection.
Much obliged, Your Lordship.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 24. Lordship, I'm for the petitioner. Lordship, may kindly grant me 2 weeks after the winter break, my lord, to file an affidavit in reply to the affidavit filed by the respondents.
Your good name, please.
Inti Longjim, ma'am.
Mr. I. Lambi, Learned Counsel for the petitioner. Press for listing the matter
After the winter break, my lord.
after the winter break, so it's to enable to file affidavit in reply to the affidavit of the
Respondents.
respondents.
Lordship, may the interim be extended.
Okay. Interim orders and conditions.
Obliged.
Next, Lordship. Lordship, I beg to mention item number 10, Lordship. Lordship, here for response number 8. I need to file my affidavit,
Respondent
Chip,
number
can-
8.
Lordship. Kindly grant me 2 weeks' time, Lordship. Lordship, it can be posted next week, after the winter break, Lordship. In the meantime, I will file my
Learned Counsel for the respondent number 8.
8, Lordship.
With consent from the other side, press for listing the matter after winter break.
Winter break.
So as to enable them to file
My counter
counter,
affidavit in opposition.
counter.
Obliged, ma'am.
Is there any interim or interim?
Obliged.
May I please, Your Lordship, I beg to mention item 34. Hearing for the petitioner, 1 week time may be given to file my affidavit in reply.
34.
Yes, 3-4.
Your good name
Yes, good.
is also Learned Counsel for the petitioner. With consent from the other side, press for listing the matter after 1 week, so as to enable or to file reply.
Yes, Lordship.
There.
Lordship, no, no. Lordship. I also beg to mention item 47. Yes. On behalf of the council for petitioner, Mr. Siti Jamir, since he is out of station, 3 weeks time may be listed after 3 weeks.
So Learned appearing on behalf of Mr. C.P. Learning. Place for this after
2 weeks.
after 3 weeks. As Mr. C.P. Here,
Similar prayer for item 49. Mr. Lordship.
Yeah.
Lordship, I beg to mention item number 27, Lordship.
item
Lordship.
number
27, Lordship. Lordship, here I'm yet to receive instructions, so kindly grant 3 weeks time, Lordship.
your order,
For the state, Lordship.
your good name.
S. Chang.
After
3 weeks, Lordship.
as concerned department. From the concerned department.
For the state respondents, Lordship.
Any objection?
I have no objection. Lordship, I also like to mention item number 36 to 40, Lordship, on behalf of additional AGB Shockway, Lordship. Lordship, I'm yet to receive
36,
36 to 40, Lordship, and locus matters, Lordship.
yes.
Lordship, here I'm yet to receive instructions, so kindly grant me 3 weeks time, Lordship. No objection.
No. After
After 3 weeks, Lordship.
here,
Obliged, Lordship.
That's for Lordship. Lordship, I'd like to mention the last item, item 64. Yeah, ladies are completed. Let this matter will come up after tomorrow on Thursday.
Thursday, your good name, please.
More ancient
Learned council, learned,
state responses, all the state responses.
learned. Council for the state respondent with consent from the other side, plus for this interpreter, that's 13.
Obliged.
There,
Lordship, I would like to mention item 61 and 62.
that has already been mentioned.
61 and
62 already mentioned.
64. Obliged.
Lordship, I beg to mention item number 35. State is yet to file affidavit, Lordship, so kindly grant me 3 weeks time.
Objection.
On the other side, this is also learning council for the correspondence interpreter after 3 weeks. There,
May I please, Lordship? Lordship, I beg to mention item number 52. Lordship, kindly let the matter come after 2 weeks.
your good name,
Mane Konya.
not there in the.
Yes, my Lord, I'm appearing on behalf of my senior Mojan.
Mr. So learning council, appearing on behalf of Mr. Learning council for the petitioner. With consent from the other side,
Yeah, YP Gupta for railway.
with consent from the other side, Mr. Y.P. Gupta, learning council for the railway.
Yes.
Price for this matter after
2 weeks.
2 weeks. There are like
Obliged.
Lordship, item number 55. Kindly let the matter come after a week.
so learning council, appearing on behalf of Mr. Petitioner. Any objection?
No, Lordship.
With consent from the price for this after
1 week.
1 week. Here,
Lordship, similar prayer for item number 57. Lordship, here I'm appearing for the respondent number 5.
so learning council, appearing on behalf of the respondent number 5.
Yes, ma'am.
Consent from the other side, price for this after
A week, ma'am.
after
It's your for the petition.
a week. There is according to allowed. Okay.
Lordship, item number 12, Lordship here, ready to file a reply, kindly grant us 2 weeks time.
And you are appearing on behalf of Mr. Mauzaman.
Yes, ma'am.
Price for its income letter after
2 weeks time.
2 weeks. Counter. Here,
With your pleasure.
Mr. Lordship. Lordship, I'd like to mention item number 45. Here, Lordship, service report is still awaited for respondent number 2. So 3 weeks time may be granted to us. to file a-
45.
Yes, sir, Lordship, 45.
You got a petitioner,
Yes, your Lordship.
your good name,
G. Kamai. Lordship, there is also an interim order.
you are appearing on behalf of.
AG Momi.
Price for listing the letter after
3 weeks.
3 weeks. There is interim,
Pardon, your Lordship.
there is interim.
Yes, your Lordship.
Then if your order shall come in.
Yes, your Lordship.
For motion, item number 1.
May it please, my Lord.
Yes,
My lord, the petitioner here is praying for a direction for regularization of our service as per the office memorandum dated 17 March 2015, Lordship. And this office memorandum provides for Lordship for those work charge employees who have served for more than 30 years and more, Lordship, will be regularized for those work charge employees who are enjoying scale of pay, Lordship. So the petitioner herein has been serving for more than 34 years, my lord. She attained 30 years in service on 18/7/2019, but till now, her services have not yet been regularized, Lordship. She's on the verge of retirement, Lordship. She will be retiring on 30/7/2024. So, Lordship,
yes, who is for the other side?
May it please, Lordship. My lord, since the petitioner, she has submitted a representation on 13/11/2023. So, my lord, direction may be issued to dispose the representation. And my lord, as per the office memorandum dated 17/9/2023, petitioner is eligible.
Eligible.
Yes, ma'am.
Lordship, she attained 30 years in service in the year 2019. So, Lordship, and she has been waiting for her
30 years or
regularization.
34 years.
Yes, Lordship, 34 years and some months, Lordship.
So, my lord,
So, this a direction may be issued to regularize her service since she's eligible. It can be, the matter can be, my learner friend can take instructions and on the next day we can dispose of the petition, Lordship.
What is this, the representation is pending, you obtain necessary instruction?
so my lord,
Yes, Lordship.
instead of keeping pending, your lordship may direct the state authority to dispose the representation.
Have no problem in using that. Whether it will serve the purpose or not, that has to be seen.
Yes, Lordship. Since her service is squarely already covered and she's eligible, Lordship.
She will be retiring within the next
Yes,
8 months.
Lordship.
Then, my lord, your lordship may direct the state respondent to consider the case as per OM dated 17/3/2015.
No, you first obtain instruction.
Yes.
Let this court know about the position
Yes.
of that representation. What is that? Your good name?
To show long, Lordship.
Learned counsel for the and also what is that?
Itipapo,
Learned,
Itipapo,
learned,
government advocate, yes, ma'am.
for the state respondent. In the This petition under section 226 of the Constitution of India. The petitioner. Namely, Srimati Nandini has prayed for swing direction to the respondents for regularization of our service with effect from 18/7/2019 with all consequential benefits as per the scheme adopted by Office Memorandum dated 17/3/2000. The learned counsel for the petitioner submits that the petitioner has been working as in what capacity he has been
Work church,
as
Kalasi,
workers,
Lordship.
skill Kalasi.
Yes, Lordship. She was initially appointed as skilled labor, but after the upgradation to scale of pay, she was upgraded to
Skill
Kalasi.
labor under the establishment of executive engineer PAC division Gauhati, Nagaland. And thereafter, by office order dated 15 January 2020, she was upgraded to the post of workers Khalasi. And since then, she has been working for last 34 years in the department. And she is entitled to be regularized in view of the office memorandum dated 17/3/2015, but she has not yet been regularized by the state response. Then notice be issued returning in 2 weeks. No formal notice is required to be issued since Mr. So-and-so learned counsel appeared on behalf of the state respondent and received notice. However, extra requisite copy of the petition will furnished to him during the course of the day. The learned state counsel submits that since the petitioner has filed one representation on when the representation was filed
13/11/2023, Lordship.
13
11/2023,
13
Lordship.
11 2023, which is annexed with the petition as Annexer E. This petition may be disposed of by directing the state respondent to dispose of the said representation. However, considering the submission of her site and also considering the facts and circumstances based on record, this court is of the view that the learned state council shall obtain necessary instruction and advise this court about the latest status of the representation dated 13/11/2023 passed filed by the petition on next date. Place the matter after 2 weeks. All the matters are same.
Yes, Lordship. All of them have
Till
served for more than
five.
30 years.
Five,
Yes, Lordship.
same order. Same order.
Much obliged, Lordship.
For motion, item number 6.
May it please, my lord.
Yes.
Lordship, here I am claiming invalid pension, Lordship. Because,
Pension.
yes, I was recruited into the Assam Rifles. In the year 2013, I underwent basic training. And during the training process, Lordship, I sustained injury. Because the Assam Rifles training, it involves physical training. So during one of those training, I suffered multiple fractures, Lordship, and especially my 8th and 9th ribs, it was broken. So I was treated at the Assam Rifles Hospital, Lordship, and then since the injuries were so severe that I was referred to another hospital, Lordship, another government hospital, that is the Civil Hospital, Dimapur District. And then I was treated there, Lordship. And the treatment was such that I had to, Lordship, undergo treatment for several years. And then after that, after several years, Lordship, I went back to my regiment and then praying for me to continue, to allow me to continue my training, or to have me, to accept me as a recruit, Lordship. However, Lordship, they have refused. And under the rules, Lordship, when a sepoy, in the discharge of his duties, which includes training also, suffers injury, then, Lordship, when the injury is more than 20% under Rule 173, I am entitled to receive invalid pension. However, those was neither informed to me, and instead being a model employer, Lordship, or to have informed the petitioner, the sepoy, that he is entitled to receive invalid pension if his injury is of such nature that he becomes unfit to continue in his service. But those exercises, those information were never given, Lordship. And Lordship, one application was shown to me, Lordship, during my communications by in written form with the Assam Rifle officers, that I have submitted a resignation letter, which I have never done, Lordship. They have even produced an affidavit, Lordship, and those three witnesses in that affidavit, I don't know any one of them. And how can somebody who is unknown to me, how can he bear witness to my resignation? So, my lord, at this stage, Lordship, my humble prayer before this honorable court is that notice may be issued, my lord, and let the respondents file their affidavit, and then we can have a proper hearing on the merits of the case. I have served notice to the
Yes, they were
respondents.
appearing on behalf of central government.
That's right. And this is, I'll accept notice on behalf of the response.
Heard Mr. Sandy and the learned council for the petitioner, and also heard Mr.
Yamawati.
learned CCC.
Yeah.
For the respondent number 1, 2, and 3. And 4. In this petition, under Article 326 of the Constitution of India, the petitioner, A2P Utsan, has spread for listening direction to the respondents for granting invalid pension. Mr. Sandy Younger, learned counsel for the petitioner, submits that the petitioner was appointed as Sapai under the basic military training at Assam Rifles Training Center at School, Dimapur, Nagaland. By appointment letter dated 20th to 2013. And while the petitioner was undergoing training, he suffered multiple fracture of multiple fracture of 8 and 9 ribs in the month of August 2013. Thereafter, he was under treatment at District Hospital, Dimapur.
Initially, Lordship, I was treated at ARCH surgical specialist, that is Assam Rifles Central, Assam Rifles Hospital.
At first at ARCH Hospital. Where it is situated?
At Dimapur, my lord.
At Dimapur, and thereafter he was shifted to District Hospital, Dimapur.
Yes, I was referred to District Hospital Dimapur.
And he underwent medical treatment for several years together. And when he recovered in the year 2020, He filed on representation of 3/2/2020 to the respondent number 4 requesting permission to resume his training. However, he was not allowed to join, and by letter dated 15/2/2020, the petitioner had requested for discharge from service on 7/12/2030. On the ground that the petitioner has requested to discharge from service on 7/12/2023. And thereafter, the petitioner filed another representation on 3/2/2020, requesting the respondent number 2 to enter into the matter, as he has never submitted any resignation letter from his service. But his request for reinstatement has never been considered by the respondent. Then, being the model employer, the respondents have not been providing him the invalid pension. Let notice be issued to the respondents returnable in 4 weeks. Since Mr. So learned, CCC has appeared and accepted notice on behalf of all the respondents. No formal notice is required to be issued. However, extra requisite copy of the petition will furnish to him during the course of the day. This is the matter after
4 weeks, my lord.
4 weeks.
Deeply obliged, lordship.
For motion, item number 7.
Maybe His Lordship,
Yes.
the senior leading this case has personal difficulties today, so can this matter may be adjourned for the day?
Yes, your good name.
I am Your Lordship.
Mr. I himself learned counsel appearing on behalf of Mr. Singh. Learned senior counsel. I to always think of matter after
Possible for the day, Your Lordship?
for the
Thursday, Your Lordship, that is.
Thursday.
Yes.
Thursday. Yes. So CP is aware, but it's senior counsel. Could not appear before the court today. There is accordingly allowed. Rest is on this Thursday.
Not so much.
For admission, item number 13.
May I please lordship,
Yes.
in the last occasion, the state was directed to file affidavit, to file status report by affidavit, and I have already filed, my lord. Lordship, my lord, yes, my lord, I'm informed that the matter is under consideration, and since it is a matter of accreditation, so it will take time. So the lordship will kindly grant another 3 weeks time, my lord.
No objection, your lordship.
Or so learned counsel for the petitioner. Learned counsel for the state respondent. The learned counsel for the state respondent that order of this court dated 16/10/2023 by affidavit in opposition. And also submits that the matter is under consideration and it will take time and space to listen the matter of that there is a potential allowed less is unless the matter of that chiefs was to
Much obliged.
For admission, item number 17.
Maybe His Lordship, here the petitioner is seeking for service regulation as per the OM, Your Lordship. And then now the state respondents, they file it, they were in a position where they annex office letter where
it clearly states as written by the chief engineer, your lordship, stating that two employees of workshop employees who have completed 30 years of continuous services on 1/1/2022 to 36/2022 are under PWD Mechanical Engineering Department. Their service has been duly verified by the district level verification committee and found to be fit for regularization under the scheme, your lordship. Where my name is also its serial number 2, your lordship. So since the department is considering the case of the petitioner for regularization, so I pray that the petition may be disposed of by granting some time, your lordship.
Time.
Yes, sir, within some specific time period, your lordship.
May I please, my lord. Lordship, the matter pertains to regularization of the completion of 30 years of service by the petitioner. Now, your lordship, the government has brought up an office memorandum which the petitioner has pointed out, my learned friend here. Your lordship will find that particular office memorandum at page 19 of the writ petition. That is annexure 6. Page 19, your lordship. Now, this office memorandum provides the schemes for regularization and absorptions of work charge and casual employees, your lordship, who has completed 30 years of service, continuous service. Now, here, your lordship, I just wanted to point out that there are certain conditions which are to be applied before the regularization of the service is given to the petitioner, basing on this office memorandum. Your lordship, the conditions your lordship will find it at page 21. Page 21.
Yes.
It states that conditions for implementations of the schemes for regularizations and revisions of pay. We are concerned with clause 1, 2, and 3, your lordship. Clause 1 states that, if I may be allowed to read, my lord. Clause 1 states that each department shall prepare a detailed list of all such work charge and casual employees in joint scale of pay who have completed 30 years or more service as on 1/1/2015 and whose cases are proposed for regularization indicating name, designation, date of birth, date of entry into service, date of retirement, pay scale, and existing total emoluments, pay scale admissible on regularization, total emoluments after regularization, and additional financial implication. Clause 2 says, your lordship, the list shall be certified by the district level verification committee to the effect that the incumbent included in the list are verified and found genuine. Lordship, the department has already done this, and I have annexed it in my affidavit in opposition that the district level verification committee has already given its report and has recommended the petitioner for regularization, your lordship.
District
Leveled verification committee. Lordship, the report will find it, your lordship will find it page 6, annexure A of my affidavit in opposition, my lord.
Yes.
If I may be allowed to read this letter, your lordship. Subject is scheme for regularization and absorption of work charge and casual employees who have completed 30 years of continuous service as on 1/1/2022 to 36/2022. Sir, with reference to the government office memorandum cited above, I have the honor to forward herewith 2 notes of work charge employees who have completed 30 years of continuous service as on 1/1/2022 to 36/2022 under the PWD Mechanical Engineering Department. Their service has been duly verified by the district level verification committee and found to be fit for regularization under the scheme. So this clause, your lordship, we have already complied with. Now, your lordship, clause 3 says, I'm back at page number 21, my lord.
Yes.
Clause 3 says, formal proposal for conversion of posts into regular ones to accommodate the employees proposed for regularization shall be submitted by the concerned department first to the PNR and proposed and then to the finance for clearance and concurrence. After obtaining PNR and finance clearance, the department concerned shall take up the proposal with the cabinet for approval. Only after obtaining cabinet approval, necessary notification for regularization in service shall be issued. So this part is left, Your Lordship. So if sufficient time can be granted to us, Your Lordship, because it has to go to the PNR, then to the finance, then the cabinet approval. So if sufficient time can be granted to us so that we can comply, we can regularize the service of petitioner as per this office
Sufficient
memorandum.
time means how much time?
6 months' time, Your Lordship.
6 months, Your Lordship.
Too long.
Because Your Lordship, the office memorandum again says that the person whose service is supposed to be regularized will have to be sent in pages. The first page will start on 1st of July and 1st of January every year. Your Lordship will find that at page 20. Page 20, my Lord. Page 20, the first para, Your Lordship, in respect of those, if I may be allowed to read, my Lord.
Yes.
In respect of those work charge and casuals employees in scale pay and who have completed all will be completing 30 years of continuous service after 1/1/2015. Their cases of regularization will be taken up subsequently in 2 pages, as on 1st of July and 1st of January every year. The procedures and terms and conditions will be same as laid down in this order.
So 1st of July and 1st of January.
January, Your Lordship.
So January still there is 1 month, 1 more month.
Yes, yes.
Will you not be able to complete the process within 1 month?
No, Your Lordship, in the PNR and then the finance department, all these things consume some time, Your Lordship. Then after that, cabinet for the cabinet approval. All these things consume some time, Your Lordship.
But
If it is just one department, Your Lordship, yes, I understand. 6 months' time is not a reasonable time.
in the meantime, some of the candidates will retire.
No, Your Lordship, even after the retirement also.
After retirement.
Yes,
there
yes,
is
yes.
provision
Yes, yes, Your Lordship.
for regularization.
Yes, yes, yes. Because their regularization
After retirement.
process has already been initiated before their retirement, Your Lordship.
Yes, how much time can be granted?
Your Lordship, 5 months, Your Lordship, and then keeping and record the office leader which they annexed in the, yes, Your Lordship, in the
No,
position.
but this 1st July and 1st January.
Yes, my Lord.
So within 1 month, it will not be possible for them to complete the process. So definitely next target is 1st of July
Yes, Lordship.
and 7 months.
Yes, Lordship, if the department will do the process expeditiously, Your Lordship, no problem for that.
No, within within 1st of July next year.
Lordship. Lordship.
Obliged, Lordship.
Deeply obliged, my Lord.
Next item.
For admission, item number 21.
Yeah, please, Your Lordship. Lordship, I beg to mention on behalf of K. Angami Lordship. Kindly list this matter after 3 weeks, Lordship.
Why?
We are yet to file counter, Lordship.
Yet to file?
Counter. To file affidavit in opposition, Lordship.
So and so, learned counsel appearing on behalf of Mr.
K. Angami Lordship.
K. Angami. Learned
Senior government advocate, Lordship.
senior government advocate with consent from the other side, price for listing of letter after 3 weeks.
3 weeks, Lordship. Interview may be allowed to continue.
We are
Right, Lordship.
allowed, till next day, report itself complete.
Right.
Next item.
For admission, item number 26.
Lordship, I am also similarly situated as the petitioners in item 17.
Acha.
I'm serving in the department for more than 30 years, and I absolutely fall in the category laid down in the office memorandum 2015. And the department have written to the PNR department, my parent department, that is the PWD department, for regularizing me. And I am at serial number 6 in the list that has been submitted to the PNR, which is enclosed at page 10 of the affidavit filed by the state respondents on 16th of October 2023. They have filed 2 affidavits, my lord.
Page 10.
Page 10. Page 10, not my writ petition, but the affidavit filed by the state respondents. The table has been given.
Page 10.
10, yes, my lord.
You are in serial number 6.
6, lordship. So my prayer before this honorable court is that lordship, a fixed stipulated time may be given to the respondents, lordship, within which time they may complete the exercise for my regularization.
Yes, as pointed out earlier.
Yes.
The process has to be completed within 1st of January and 1st of July.
Yes, lordship.
So within 1st of January, it may not be possible. Will it be possible on your part to complete the process?
Yes, Lord.
My process, lordship, it initiated some months ago, lordship. So I believe, yes. I am in fact better placed than the petitioners in petition in item number 17, lordship.
Yes.
A series of communication letters between the department authorities have also been enclosed here, which amply proves that several months ago, the process for my regularization has already been initiated.
Within 1st of January, it will be possible to complete the process. Right?
Yes.
Okay, we will record your results. We'll dispose of the process.
Deeply obliged, my lord.
Next.
For admission, item number 33.
May it please your lordship. Lordship, may kindly grant me 3 weeks' time to file my affidavit.
State
For
council.
the state, yes. Your lordship.
You inform the other side
Yes, your lordship.
with consent from the other side, press for granting her 3 weeks time.
Yes, your lordship.
Here is accordingly allowed. Please the matter after 3 weeks.
For admission, item number 41.
Your Worship, item 32 has not been called. Yes, ma'am.
Someone has mentioned.
This case relates to regularization. And the counsel for the state respondent is ready for hearing also.
Someone has mentioned 832.
Yes,
Who mentioned
Lord.
it?
My lord, this matter relates to regularization. The petitioner has served.
That's all right, but in the
Yes.
morning, someone has mentioned the matter.
Similar, Lordship, similarly situated as those other two just.
17,
And
Yes.
26, yes, my lord.
17 and 20,
6,
26.
yes, my lord. It can be disposed of since the parties are ready.
Yes, the case of the petitioner is covered by the 2015 OA.
Yes.
Yes. The
So
petitioner,
when the process of regularization was initiated,
the case of the petitioner, your Lordship, is covered by the 2015 OA, which
no, that's
says.
all right, we agree. But when the process was initiated,
My lord, I have submitted my representation for regularization
yes, when,
and it was in the year 2021.
yes,
And my
representation was forwarded by the executive engineer to the government. Until now, my service has not been regularized. So I'm here before this honorable court to regularize my service. And since this matter is covered by OM 2015, and this matter is similar to item 17 and 26. And the petitioner has served the department for more than 32 years of service, and he was work charged on a scale of pay. So this is squarely covered by 2015 OM. And similar writ petition was also filed, and I have enclosed that judgment also.
That's all right, but someone has mentioned. Now,
Ms. Noli is not in this case. The government counsel is more injured in this matter, my lord.
is he available? No, wait for something.
Yes, ma'am.
Let her come. Next item. 41.
For admission, item number 41.
Please, Lordship.
Yes.
Lordship, this matter was filed along with 6 other similar writ petitions praying for payment of pending bills. Lordship, in all the 7 writ petitions, the pending bills have been paid. And on the last occasion, only 6 of the 7 writ petitions were listed, and the 6 were disposed. And in this matter also, the pending bills have been cleared. So as the petitioners' grievances has been replaced, let the matter be closed.
This may be closed.
Yes, ma'am. The pending bills have been cleared.
May I please, my lord?
Yes.
Lordship, this matter is in fact analogous with 5 others matter. There is WPC 2023 to 226 of 2023. Now this matters WPC 220 of 2023 and 222 of 2023 to 226 of 2023. These matters were listed on 2011-2023. And in all this writ petition, including the present writ petition, the petitioner was seeking their pending bills. Now, Your Lordship, the pending bills has already been cleared by the state respondent.
So this matter.
Yes, and therefore, when the other matters was listed on 2011-2023, this honorable court has disposed of the matter. But since
Then we'll pass similar.
yes, we may pass a similar order, Your Lordship.
We'll call that petition number 2020.
Yes, my lord. And 222 to 226 of 2023. ma'am. Yes, ma'am.
Okay, we'll pass similar.
Lordship, I am deeply
Deeply
obliged.
obliged, Lord.
For admission, item number 42.
Yes, Lordship. Lordship, I beg to mention on behalf of K. Andami, Lordship. Lordship, here I'm yet to receive instructions, so kindly grant 3 weeks time, Lordship.
Gauhati is senior government.
Senior government advocate, Lordship.
Other side, Pressful district commander. When?
After 2 weeks, Lordship. No,
Is there any threat?
no, Lordship. Obliged, Lordship.
For orders, item number 46.
Your Lordship, I'm appearing on behalf of my senior, his in-law him. since he's out of station due to some personal difficulties. Lordship, kindly list this matter after 3 weeks. Yes, Lordship.
Office note dated 31/10/23 indicates that service report in respect of respondent number 6 is still awaiting. Accordingly, it is provided that registration shall raise the matter after 3 weeks.
3 weeks, yes, Lord.
After 3 weeks, awaiting service report of respondent number 6. Next one, so learned counsel appeared on behalf of
Hasin Lohim.
learned counsel for the issue.
Much obliged.
For hearing item number 51.
My sincere apologies, Your Lordship. Your Lordship, I beg to mention item number 32. Earlier, this has been mistakenly mentioned, Your Lordship. I was
Gotcha.
misinformed about it.
Gotcha. Okay.
Thank you, most obliged, Your Lordship.
30.
Lordship, due to some miscommunication, it was happened like that in the presentation.
So your case is also covered by the office memorandum
Yes,
of
madam.
2015.
Yes, madam.
So when the process was initiated, process of regularization.
My lord, I have submitted my representation and
21.
my representation is enclosed. At annexure E, page 25. Page 25, annexure E.
Your file has already been with the stenographer, private secretary. Fine.
Yes, yes.
Yes, 51, I think, next item, 51.
My pleasure, Your Lordship. This matter also pertains to the same issue which was heard earlier, Your Lordship, regarding workers regularization, Your Lordship. But then, Your Lordship, before this, Your Lordship, the petitioner approached this honorable court, Your Lordship, and then on 17/9/2019, Your Lordship, this honorable court directed the respondents to consider the case for regularization as per the OM, Your Lordship. 9/2019. That is in WBC 146 of 2019, Your Lordship. It was disposed of directing the state respondents to consider the case for petitioner as per the OM, Your Lordship. And then after that, Your Lordship, since the state respondents didn't take any steps, so I filed one contempt petition, Your Lordship, which was registered as contempt petition 7G of 2020, Your Lordship. And then in their 7G of 2020 for non-compliance of the court's order, Your Lordship, earlier court's order. But then in the affidavit in opposition in the contempt petition, they have included one documents, Your Lordship, where they have submitted to the government, Your Lordship, for regularization as per the OM, Your Lordship. That's why the contempt petition was closed off on 16/11/2023, Your Lordship. And then now this writ petition is pending, Your Lordship. And then here also they have annexed the same annexure which it includes in the contempt petition, that is page 4 of the affidavit in opposition filed by the state respondents, Your Lordship. Page 4, annexure 1. Mayor, Your Lordship,
Page 4 of
their affidavit in opposition. Relevant, they've included at page 7, Your Lordship, relevant in mixture.
annexary.
Annexary, yes, Your Lordship, where the additional chief engineer, office of the chief engineer, PhD, written to the principal secretary, government of Nagaland, on the subject, submission of proposal for regularization and absorption of work charge service complete employees who have completed 30 years or more continuous service as on 7/1/7/2019, Your Lordship. And then this letter was sent on 3rd October 2019, Your Lordship. So, Your Lordship, my only prayer is that since the department are considering the case for regulation as per the OM, Your Lordship, for that I don't have any grievances, Your Lordship. But then since the only prayer is that it was written in the year 2019, Your Lordship, and then present is already 2023, Your Lordship. There has been an indefinite delay, Your Lordship. So at this stage, I just pray that keep a strict direction to the state respondents to consider the regulation as per the OM, Your Lordship. That's my only prayer, Your Lordship.
I'm appealing for the office of the Principal Accountant General, Lordship. As far as my role is concerned, Lordship, my part comes only after the government take a decision and they send the pension papers for authentication. We are there only to authenticate the pension. But my role has not yet come, Lordship. It's the matters with the government.
Since the case of the petitioner has been forwarded to the government, it could be a matter of time, Your Lordship.
Matter of time. means-
Yes, Your Lordship.
So matter of time means?
Your Lordship, there are a procedure as per the scheme. So
Yes.
it will go through the finance, PNR, and then rationalization of manpower, then only with the approval of the government.
So how much time it will take?
That, Your Lordship, we cannot say. But yeah, roughly 6 months, Your Lordship. Yes, Your Lordship.
Yes.
Yes, if the state respondents are going to comply within the 6 months, then Your Lordship, for that, no problem. Your Lordship. But then mounting is that
No,
this,
whether they have initiated the process.
That we have, Your Lordship, proposal has been sent, Your Lordship. As
but
per-
Your Lordship,
No,
it
whether
was in the year
the name
2019.
of the petitioner is.
Yes,
there in
it's
the document.
included, if Your Lordship may see page 8 of my affidavit, Your Lordship. Serial number 10 is the petitioner saying, R. Bamba Yamchunga. The last page of my affidavit,
Page number 8.
page number 8, Twin
Serial
Sun
number.
Division, Twin
Yes.
Sun Division, the
Serial
last
number?
serial number 10, Your Lordship. Yes, Your Lordship. Serial number 10.
That's
So the matter may be closed, Your Lordship.
within 6 months.
Your Lordship.
Your Lordship, in that case, Lordship, only 4 months may be given, Your Lordship. This letter was sent in the year 2019, Your Lordship, October. It's more than 4 years, Your Lordship. And then now the petitioner has already retired from service.
Your Lordship, time bound may not be appropriate, Your Lordship, because the scheme does not mention regarding that time.
But then we have to fix the timeline, otherwise he will return from service before regularization.
Lordship.
Otherwise, the petitioner may retire from the service before regularization.
No,
He has already
Your
retired,
Lordship.
Your Lordship.
Already?
Yes, Your Lordship.
Yes, I've been waiting since from the year 2020, Your Lordship. Now it's been 3 years, Your Lordship. That's why I'm praying only for 4 months, Your Lordship.
Lordship.
As far as the retirement is concerned, it will have no effect because there's already an order of this honorable court
Yes.
in the earlier petition
Acha.
to regularize the service
Yes.
as per the OM. So that time he was in service. So retirement will have no effect. Lordship. Like the government is saying, it's a matter of time. And for that matter, after they process the paper, then the pension comes to us Lordship, for authentication. So that takes time. Because we might be involved after the government take a decision, Lordship, the office of the Accountant General. Because the pension definitely comes to us, we have to authenticate, we have to see the documents. And after authentication,
No, since the person has already retired from service, then it is more urgent. Because
yes, it's just a matter of time, Lordship. It might be done within the 2-3 months or so, Lordship.
we will grant you 4 months time. You have to
That case,
complete
Your
the
Lordship,
process.
let it be 6 months time, Your Lordship. 6 months time. Your Lordship.
No, whether the person already retired from service.
Yes, yes, Your Lordship.
4 months.
Yes, Lordship.
For admission, item number 32.
Yes, ma'am.
Yes.
My lord, since the petitioner has served the department for more than 32 years of age, and since it has been, the case of the petitioner is covered by the OM of 17/3/2015, the petitioner has submitted a representation to the respondent authorities for regularization. And the same application, the same representation was forwarded by the executive engineer to the respondent for consideration of the regularization. However, till date, the petitioner case has not been considered for regularization. And if this honorable gives a direction to the respondent authorities to regularize the service of the petitioner within a time bound period.
Yes.
Yes, Lordship. Look, the petitioner has fulfilled the criteria as enshrined in the office memorandum.
So the process of regularization is initiated.
Yes.
When it will be completed.
Regularization, as per the OM, it has to be sent in the month of January and one in the month of July. July. It is there in the OM, it is very clearly written in the OM, in the Lordship. You can see the OM.
I have gone through it.
Page 20 is the office
I have
memorandum.
already gone through it. Now, my question is whether you will be able to complete the process within January of 2024.
Yes, yes,
Within January?
yes.
Okay, then we will direction to complete the entire process within January of 2024.
Much of
Okay.
For admission, item number 41. For motion, unlisted motion.
Yes.
For hearing, item number unlisted motion.
Yes, Lordship. Lordship, the petitioner is a settler and landowner in the village of Gauhati village under Chimukitima district, Nagaland. Lordship, the petitioner has.
Where is the notice?
Lordship, this is not a notice but an order. Without issuing notice or show cause to the eviction, the petitioner was directly issued this eviction order. That is at page 24.
Where?
Lordship.
Page?
Page 24, annexure 5. Lordship, I'm allowed to read. Chumukiti Maswanso, dated the November 23, eviction order. Whereas the Office of the Commissioner, Nagaland, Kohima, white order dated so-and-so, dated 16 August 23, and Home Department, so-and-so, dated 24 July 23, has given approval for eviction of unauthorized structure near Gauhati village. And whereas the Office of the Commissioner, Nagaland, white so-and-so, dated 15 March 2022, has directed to strictly enforce status quo and refrain all parties from carry out fresh activities. You are hereby directed to dismantle the illegal structure and vacate the area along with the structure and belongings within 14 days from the date of receipt of this notice. Lordship, as per the
When you have received the notice?
on 28th, Lordship.
On
20th of November. Order was issued on 15th November, but I received on 2011. Lordship may see the provisions, Lordship. Under the Nagaland eviction of persons in unauthorized occupation of public land, 1971. Volume 3, Nagaland Code Volume 3. Lordship, I may Volume 3. Lordship, the relevant portion is at page 3, Lordship. Page 3. Page is numbered at the bottom.
yes.
Lordship. The last paragraph, Lordship. Issue of notice to show cause against order of eviction to unauthorized occupation from public land. 5. Suppose 1. If in respect of any public land, and Lordship, I may price is on record that the land in question which the petitioner is occupying is a village and is not a public land, Lordship. Even admitting, even though it is a public, even though not admitting, but even otherwise it is assumed to be a public land, the government should have issued a show cause notice as per this provision, Lordship. So, Lordship, I may be allowed to read. Section 5, clause 1. If in respect of any public land, the Deputy Commissioner is of an opinion that such land is in the unauthorized occupation of any persons or persons.
Your land is private land.
Private land, it's a village. It's a village. Lordship, and I was allotted the land by the GB of the village. The village was set up in 1973 and in 2018.
Allotted in the year?
2018. During 2018, Lordship.
By?
Lordship, Annexure A, Lordship, Annexure
No,
A.
who allotted it?
By GB, Lordship, the Gambura. The head GB, to be precise, Lordship. So, Lordship, the land is a private land, a village. And in the year 2018, after allotment, he has constructed a house and he is living with. Under the shelter, he has constructed a house and he sheltered with his wife and 3 children, Lordship. And till the date he was issued the notice, the eviction order, he was in peaceful possession from the year 2018 till the date, Lordship. In fact, only on the 15th, on the 2011-2023, the petitioner was served with this eviction order, Lordship, without following the provisions of this, the Nagaland eviction of persons in unauthorized occupation, Lordship. Lordship, before following by the Act, Lordship, the petitioner should be issued a notice or a show cause notice as to why his occupation he should not occupy the land and why he should be evicted, Lordship. He should be given opportunity, but that opportunity has not been given, Lordship. And he was directly served with this eviction order, Lordship. And those two communications reflected in this order are internal communication between the DC and the Commissioner, Lordship. And not, which was never served to the petitioner, and there was not a copy or a letter to be served to the petitioner. So without giving an opportunity to be heard, the petitioner was served with this arbitrary order of eviction order, and he was ordered to evict the place within 14 days, Lordship.
So that is your case.
Lordship, that's my case, Lordship. So at this stage, Lordship may be kind enough to grant an interim order, grant an interim to stay the eviction order, Lordship.
Yes, madam. Madam, are you appearing in this case? Have you served notice?
We have served copy, but I think we served this morning
It has
only.
been served. We have no idea.
Acha. So where is the
Anyways,
served-
your lordship, I'll accept notice on behalf of the state.
Yes.
Lordship, a short notice may go, your lordship, regarding the interim.
Lordship. The notice was issued on the 15th, Lordship. And if 14 days is confirmed as per the order, it's tomorrow is last date, and tomorrow is a DB,
Last day.
DB date. So Lordship may kindly pass an interim, Lordship, in the interest of justice, Lordship. This order, this eviction order has been passed without following the provisions laid down in the
Madam,
act,
there's
Lordship.
a Annex R5, the eviction order.
Your lordship.
So 14 days time is granted, and this was issued on 15th of November. So tomorrow is the last day.
Your lordship, I'll have to go through the brief and obtain instruction without that, your lordship.
Okay, we will
Lordship,
take
this-
it up after some time then. In the meantime, you obtain instruction.
Lordship,
If
lordship,
necessary, we can take it up at 2 o'clock.
at 2, your lordship.
Yes.
For hearing, item number 54.
This my lord.
Yes.
My lord, here, my case is that the petitioner husband who was working as office peon under the establishment of Chief Engineer PWD R&B, my lord, since 1983, my lord. And my lord, while the petitioner husband was on leave, he went to his native village, that is Jharkhand, my lord. And on the way to his native village, the petitioner husband went missing on 15/9/2013, my lord. And my lord, what happened is that as the petitioner husband went on missing and he could not report to his duty, to the duty. And thereby the office of the chief engineer issued following notice to report to the duty within 15 days. However, the petitioner husband could not be traced out, and thereafter, as per the calling notice, the office of the respondent number 3 issued an order terminating the service of the petitioner, my lord. That is one part. And there, on the day the petitioner husband went missing on 15/9/2013, and on that day itself, the petitioner gave complaint to the railway thana that the petitioner husband went missing, and on the day of missing, the petitioner submitted the ID card of her husband as well as the photo. However, the petitioner was not given any report, and thereby he wrote two letters to give the report of the status report of the missing person. However, the report was not given to the petitioner till then, and thereafter here the petitioner also asked for the grant of pension. However, he was not given pension also. However, he was given only the GPF. Right. And he was issued with the termination order, my lord. So, my lord, that is the short view of the case. Now, here, my lord, as I've mentioned earlier,
My
the
question is, if the person concerned is terminated from service,
yes, ma'am.
whether he will be entitled to family pension? What the rule says.
My lord, the rule is silent on that. However, the petitioner husband could not report to the duty because he went missing, and how the missing person attend to the call of the higher authority, my lord. That is the question, my lord. My lord, let me beg your lordship as in order of sequence. My lord.
Madam, are you appearing in this matter? Yeah, what is your stand?
There is nothing wrong with the termination order because
Pardon?
there is nothing wrong with the termination order.
No, regarding
So
this
unless-
family pension?
Yes, unless the termination order is revoked, family pension cannot be granted.
That is
So
your
he-
stand.
Yes, yes, your lordship.
So, my lord,
Here,
in
the
this matter-
petitioner's husband has stopped coming to the office, so a calling letter was issued. There was no response, and therefore, termination.
That letter was served.
Yes, calling letter was served on 16/3/2015
With whom?
upon the petitioner's husband.
It was served.
Yes, yes, it was served.
He has received the notice.
That was acknowledged, your lordship.
No,
No. Who received the notice?
Your lordship, we could not, your lordship, state it in our affidavit, but we'll have to see the report, your lordship. But anyways, your lordship,
You see the record then.
your lordship,
You see the record. You go through the record. And apprise the court about the correct position.
oh, your lordship, that, your lordship. Then it may be listed next week, your lordship.
My lord, here in this petition, I am praying for three prayers I've made, my lord. One is to watch and set aside the impugn termination order. Yes, my lord. That is one, and second is to give the missing report of the petitioner husband, my lord. That is respondent number 4 and 5, my lord. And third is to give family pension to the petitioner, my lord. Yes, ma'am. And my lord, as per the
no. If she is not aware of as to upon whom the notice was served, then how can she argue the matter? Let her go through the record. So when to be listed?
Next week, your lordship.
Next week.
Next week.
No, if the person concerned is missing, upon whom he served the notice. That's the question.
Your lordship, his family members are here, your lordship. His families are here, your lordship. So on his behalf, whether anyone has accepted that, we will have to see the report.
No, actually, my lord.
If the
we have not-
petitioner's husband went missing, they should have been to the notice of the authority also, your lordship. But they never make a representation to the authority. So
My
that is
lord.
also one thing, your lordship, to be
The petitioner
considered.
made a complaint to the respondent authority, my lord. Annexation number 3, my lord.
That was dated nil, and we have admitted in our affidavit that we have never received any representation from the side of the petitioner.
But if they are saying that, how can I receive my GPF, then, my lord? That is the question, my lord. After the complaint was made, they have released the GPF of my missing husband, my lord. And they straight away given the termination order, my lord. And notice was not served to me, but when I went to the office of the respondent authority, the order was given to me.
Termination order.
Yes, my lord.
Then whom the notice was served?
I've no knowledge, I've never seen it.
Go to the record, you appraise the court. Next year. We'll fix it sorted, we'll fix it at, next year,
Yes,
next month,
Lordship.
next week. Pardon me, sir, your good name, please.
Delicacy, my lord.
Learned counsel for the petitioner and also heard this.
S. Mary.
Learned, government advocate for the petitioner. The learning government advocate for the petitioner, some step. So maybe granted 1 week time to go to the record. Here is accordingly allowed, this the matter of. Fourth of December,
4th is Wednesday. Usually TB will be there.
no, 4th of December. Monday.
Oh, okay. I'm looking at 2024 calendar, sorry. Lordship. Next week to stay, Lordship.
Agreeable? Monday.
For hearing item number 58.
May I please, Your Lordship? It's a very simple matter. My lord, the petitioner is an employee under the Northeast Zone Cultural Center. It's a society, my lord, registered but under the Ministry of Culture, Government of India. Now, Lordship, she has not been considered for promotion in spite of working for more than 16 years.
16 years.
16 years in the grade of either class 2 post.
In the grade of?
Research officer, which is a class 2 post, group C, group B post.
Where she has been serving?
She's serving in the Northeast Zone Cultural Center, Dimapur. Shortly, NEZCC.
Yes.
Now, Lordship, on 12/5/2022, as many as 10 employees were promoted. But she has not been considered for promotion. In fact, my lord, no reasons, absolutely no reason. Absolutely no reason given in the affidavit also.
10 persons were promoted. Whether
And
her name was there in the.
no, man, absolutely. In the DPC, she was not even considered.
Why?
No reason, my lord. Absolutely no reason. And that is my case, my lord, that I have not been considered for promotion in spite of my juniors, my lord, three of the juniors, my lord, who were in Group C post, class 3 post, have been directly promoted to Group A post, class 1 post. I have not been considered. And that is my case, that I am claiming for promotion with retrospective effect from the date on which my juniors were promoted, applying the next below rule. That is my case. So now, Lordship, may I kindly take your Lordship to the relevant documents and the facts. Lordship, may I kindly come to page 23. Page 23, madam.
What is this, the synopsis?
Lordship?
The petitioner is not challenging the promotion of our juniors
Yes.
who have been promoted from class 3 directly to class 1, but the petitioner is aggrieved by non-consideration of our case in spite of being eligible for promotion to the next higher grade of class 1.
No.
You are not challenging the
Yes,
order
Lordship.
of promotion.
No, Lordship, because my lord, the post against which I'm claiming is still vacant. I'm holding it. I've been given charge of that post, and the post is still vacant. And my lord, I'm not challenging the promotion of the juniors who have been promoted, but I'm just using them as an example to show that persons who are there in class 3 posts have been promoted directly to class 1 post, and I have not been considered at all. So therefore, my lord, applying the next below rule, I am also entitled to be considered, my lord, considered for promotion with effect from the date on which my juniors were promoted, if I'm found eligible. That is my case. And lordship, I'll try to satisfy your lordship.
No, one way you have not been challenging the order of promotion, but
Lordship.
the other way you are aggrieved by non-consideration of your case.
Lordship, now, if I'm not claiming the post held by them.
No, is it in the same grade?
It is in the same grade.
And
But
the
my lord,
post you have opted for is also grade 1.
she's also eligible to be promoted to grade 1. And persons who are there in grade 3 have been promoted directly to grade 1. Now, my lord, the post against which I'm supposed to be promoted is still vacant. That has not been filled up. I'm holding that post. Even now, I'm discharging the duties of the post of grade 1 post, that is the post of section officer documentation. That post, after it was vacated, I was given in charge of the post. I'm still looking after the duties of the post. And that post is still vacant. And they've said in their affidavit that DPC will be held to consider me after since the post has fallen vacant. But that post fell vacant in 2021. So if your lordship sees the facts, my lord, and lordship, I will also satisfy with that. I need not challenge the orders of the juniors because they're not holding that post against which I am entitled to be promoted. If yes, my lord, that I'm
So
entitled.
in your case, their stand is that they will consider
They have said
your
that.
case.
They have said that the DPC will be considered. What they have said is, I made a representation. At that point of time, there was no vacancy, and therefore I was not considered. And after the vacancy came about, my lord, the DPC will be held to consider my case. That's what they have said in the affidavit. But my lord, they should have, because when these promotions were effected, my lord, vacancy was already there. That is in 2021. So they should have held the DPC.
No, you have already submitted that. Why do you have submitted the representation? Then there was no vacancy.
That's what they said. That is the step. They're saying, my lord, that the first representation, when I
But
submitted
where is the document that the post is lying vacant since 21?
Lordship, I'll show.
No, you saw the document.
Lordship, may kindly come to page 31.
Of your petition?
Yes, my lord. Lordship, this is an order dated 13 December 2021. By this order, my lord, this is the retirement. C.T.S. Setsuke, Documentation Officer, Section Officer D. Under the establishment of Northeast Zone Culture Demand Center, Dimapur is hereby released from service on voluntary retirement on medical ground under such as such on 30 November 2021. On his voluntary retirement, the following is okay. Lordship, may kindly come to copy 2, number 3. Miss Thompson, copy 2, Lordship has got it below.
Copy two.
Copy two.
Yes.
Then serial number 3. Ms. Thompson Naro, research officer shall continue to perform the duty of documentation officer in addition to her normal assignment till further orders.
So this documentation officer is a grade 1 post.
Yes, documentation officer, section officer D. It's same post.
So now you have been discharging your duty as a research officer.
Research officer plus this post. Because this post after vacation.
Yes, so what is your reason then?
May I please,
It
Lordship?
appears that the post is lying vacant.
Lordship, the petitioner, in the writ petition is aggrieved by not considering by the DPC, which was held on 7 December 2021. Admittedly, the petitioner, as per the pleading, on record that the vacancy arose only on 13 December by this order. So after the DPC was held, now the petitioner is aggrieved by not considering her case for promotion to the next cadre, that is section officer documentation. Despite of the fact that there is an existing vacancy. The vacancy arose only after the DPC was completed. That is on 7 December. Therefore, her case was not considered. So all the promotions were affected as per the rules should be considered through the recommendation by the DPC. So after the 7 December 2021, there is no DPC. In fact, this honorable court has passed an order that no process should be taken up till the disposal of this matter. So in our affidavit, we have also stated, pleaded that, admitted
So
that.
there is interim direction of this court.
Lordship.
So till disposal of the writ petition, no DPC.
No process, no exertion. Yes. After 7, no DPC has been considered. So her case, the respondent is not saying that her case should not be considered. However, the writ petition, the petitioner is saying that her case should be considered. But at the time of the latest DPC, there was no vacancy because vacancy, as per the document, that was on the voluntary retirement motion. The vacancy was only in
So now we can dispose of the petition by directing the DPC to consider her case.
Lordship.
Lordship, on 9/6/2022, my lord, this honorable court passed the order said, till the next reasonable, no promotion or appointment should be made to the post of section officer, to which the petition is seeking promotion. Pendency of the writ petition shall not be a bar for the respondent to consider the promotion of the petition.
Yes, then you can consider her case.
Lordship, as per the wisdom of this lordship.
My only submission is.
Consider the promotion of consider her case.
Yes. Lordship, may I? Lordship.
Yes.
If I may.
Yes.
Lordship, after the vacancy fell, he said that when the DPC were held in the month of September 2021 and December 2021, there was no vacancy. But I was also eligible because I'm the senior most. I'm the senior most. I'm also eligible to any group A post. Anyway, after the vacancy fell, promotions, though DPC were held, promotion was not made immediately because promotions were made only.
Then why her case was not considered
Yes,
for other posts?
that is the case.
Lordship, the petitioner claim is for a particular post. No, that is a section officer documentation. No, the particular post, the vacancy was the post, it was only after the DPC was had. She was not dreaming to any other grade 1 post. Very particular. Lordship, that is a section officer documentation. That
No,
vacancy.
whether she has filed any representation. that's
Yes,
the
Lordship. Here, the petitioner has filed 3 representations. 2 representation which is lying pending is after the DPC was held. That is in 2022, 28th February, Lordship.
No, whether in her representation she has opted only for that
No,
post.
no. Lordship, kindly come to page number representation first, page number 32. Ma'am.
Yes.
This is the Lordship type copy is on page 33. Lordship, kindly come to the last paragraph. After saying all that, after saying rights, entitlement, therefore I would like to request you kind authority to kindly consider my case for promotion from the post of research officer to be as such to higher post of to a higher post of assistant director deputy any post, not just research officer.
Lordship, if we go to the page number 34, Annex 11.
And this
Along
is-
with the
this
representation
is-
that there's a
this-
particular,
This is up to the,
there's a particular in the subject, application for promotion to the post of a section officer documentation, page number 34, petition, read petition. Your Worship. He also very particular about the post, section officer documentation. Your Worship.
So now the post is lying vacant.
Lordship.
So you can consider her case.
Lordship, we are not adverse to that. So, but the DPC cannot be held independently for the petitioner. So, let her case be considered in the next DPC as and when the DPC.
But
is-
the next DPC will be held.
don't have any specific.
Then we can direct you to
Yes.
all the DPC within a specific period and to consider our case.
Since the boss is vacant, admittedly the boss is vacant and
Yes.
she's on additional charges.
Yeah.
However, as far as the writ petition in the way of the petition is concerned, she was aggrieved, the petition was aggrieved by the, non-considering her case by the DPC. So he should have challenged that. Now my learned friend, the petitioner is also questioning the seniority list. Seniority list which the petitioner has annexed in the petition as Annex 27. That the seniority list maintained by the department of responsible, she has not challenged that. These two aspects. However, considering her case for the next DPC is concerned, we have not addressed it.
Let this one more about when the next DPC will have.
Lordship, that apology that I cannot give a specific. So the Honorable God can give a direction, a reasonable time to consider DPC.
Lordship, he's saying.
Whether it will serve your purpose.
Lordship.
If we issue direction to the respondents
Yes,
to constitute the DPC
Yes.
and to consider your case.
Yes, my lord, but my lord, applying the next period of my lord, I just press a piece. Because since I've been denied promotion, I'm entitled to consider.
But
You
then
just-
already, but you are not challenging their permission order.
No, correct. That is. Yeah. Lordship, may I just please one question? Case law, my lord, a precedent, an authority, my lord. Just to show that I'm entitled to be considered with retrospective effect, my lord, from the date on which my juniors were promoted. Because, my lord, I've been wrongly denied. If there was a doubt, I've been wrongly denied. Wrongly denied.
The question is whether at the time of holding the DPC, the post you have opted for was lying vacant. Not lying vacant. Then how can they promote you?
Lordship, my case is that it is not just a research officer. My first representation was that I'm entitled to be promoted to any grade with a course. And my lordship, when we got promoted.
No, in
Lordship,
that
my
case, you
policy-
have to challenge the permission order.
Lordship, my policy, when they were promoted, DPC is one thing.
No,
DPC is
they are
one thing.
challenging the permission order. How can you? Okay, no, that's all right.
Because my case is, I'm entitled to be promoted with respect.
No, if the post is not lying vacant, which you have opted for, then how can?
Lordship, it's not opted, I do not opt.
If you want that relief, you amend your petition, amend your bear.
Lordship,
You
my-
challenge the permission order.
Yes. Lordship, if I may, if I may. I'm not claiming the post against which they've been done. Lordship, the policy. This was held in the month of September and December. The second, the last DPC was on 7 December 2022.
No, you better do one thing. We propose to dispose of this petition by directing the respondent to constitute DPC and to consider your case. And if they consider your case, if you are promoted, then you can file the representation to them to consider your promotion with respect to the date from where From which your zoning certain from.
Lordship, may I just place one case, Madam? Just if I can satisfy your lordship that I'm entitled to inform. Apply the next below.
That's all right, but one way.
Because that is,
Challenging that permission
Lordship,
order,
I
then you are
may need not challenge it, my lord, because there are case laws where it does not be challenged. Because once it's wrongly denied, my lord, then that rule has to apply, that law has to be applied.
It's all right, but you have to challenge it.
I need
The
not
permission
challenge,
order.
no, your lordship, my respectful submission is that I need no challenge. Because my lord, kindly appreciate that the promotion was effective on 12 May 2022. The post-vacant vacant as per the order with effect from 30th 11/2021. Promotions were given in the month of May 2022.
On the recommendation of the TPC. This is 7.
Why can't they hold the TPC now? They must hold
Okay,
the TPC.
we'll come back after 5 minutes.
Lordship, lordship. Those are 696.
Yes,
Lordship.
yes.
Lordship, may kindly come to page
23 of your petition?
Yes. Page 23, energy. All of this is in private. This is the first entry of my petition service. Appointed as telephone operator and operator and receptionist and establishment of such and such in the basic of such and such. May I kindly point out that there was an advertisement, Madam. She has been advertised, appointed person to an advertisement through a selection process. She was appointed through a selection process.
No, that's all like that. That has not been disputed by the respondent side.
No, just to show the facts, ma'am, if I can just.
No, not necessary.
Then, Madam, let me show, because they're saying what they have just submitted also and what they've said in the affidavit. That seniority position, that the person I'm saying that who have been promoted, my juniors, they're saying they're senior to me. Well, let's see. They are taking my promotion to the grade of grade 2, research officer. That was in 2006. And the grade of initial entry was +3. They're taking the entry level seniority, they're calling the date of seniority. I may just take your worship to the seniority list, just to clarify that even this statement is incorrect. Worship may kindly come to page 69.
No, maybe, but how this discrepancy here and there will help you?
No, worship, I'm just showing that I'm senior to this person who have been promoted. If your worship doesn't want to go in there, but
No,
then I'll just.
where they have challenged it?
They have said in the affidavit in paragraph number.
Yes.
Worship may kindly see paragraph number. 12. The affidavit.
Page number 12.
No, my lord, the affidavit, paragraph number 12, page number 8.
Yes.
May I read this one? The correctness of the amendment made in the petition is not admitted by the answering respondent. It's imperative to reiterate hearing that the petitioner is claiming to get preferential treatment in view of seniority list published by order number such, dated 6/5/2008. That by the said seniority, the petitioner is claiming seniority over 3 persons, namely such and such. While considering the said seniority list dated 6/5/2008, the petitioner is at CL number 6. The date of appointment to the present post of research officer is 18/5/2006. And further, date of continuing seniority in the present is 18/5/2006. Whereas the date of appointment and continuing of seniority in the present cadre as per the seniority list submitted by the petitioners, CP Yangalam to appear as serial number 9, and the seniority is with effect from 18/6/1996. Lordship, which I want to point out that this 18/6/1996 is the date of counting seniority in the grade 3 post, madam. And I'm in grade 2 post. And CL number 10, Ashim Devnath, his seniority is counted with effect from 13/5/1997. That's also grade 3 post, madam. CL number 12, Sri Yeshalamba, his seniority is counted with effect from 16/2/1998, respectively. Again, it's grade 3 post, madam. Whereas I was already promoted to grade 2 in the year 2006. So definitely, my lord, my seniority in the level of grade 2 will be 2006. So they cannot, they're counting the initial date of entry to say they're senior. If my initial date of entry is 1992, my lord. So therefore, this statement also is incorrect. That's what I just wanted to point out. Entry level, my lord, we all entered at the level of, in the level of grade 3. Mine is 1992. Therefore, and I was promoted, already promoted to group B, grade 2. And then, therefore, my lord, at page 69 is the seniority list. I appear above them at CL number 6. 69.
Yes.
My name is serial number 6. Above them, my lord, this is a seniority list as on 31/3/2022. March 2022. And my name is at serial number 6, much above them, my lord. And my lord, may kindly see at column number there of I'm in the level of joining post subsequent. She may kindly see present grade. Column number 5, my lord. Column number 5, research officer. I'm in the grade of research officer, which is a class 2 post, my lord. And then Lordship may kindly see date of content seniority in class 2 post is 18/5/2006. Whereas, my lord? Whereas?
But the others were
At serial number 9, my lord.
9,
Ah.
10, 12.
Serial number 9. Lordship, this is column number 5, my lord. UDC grade 3. And continuum of seniority is last column, 18/6/1996. So that is seniority in the grade of grade 3, not grade 2. So therefore, I'm senior. That's why I'm placed in serial number 6. So seniority is not a problem, but only issue now is whether I'm entitled to be promoted with retrospective effect when from the date on which my duties were considered and promoted. That is the only case which is. Otherwise, they also say that they'll consider the DPC and consider my promotion. But Lordship, whether I'm entitled now with retrospective effect, that is the only issue. If I can satisfy your Lordship, my lord, on that, Lordship may kindly.
no, the problem is that I have not challenged the promotion order.
Lordship. Problem, my lord. And since that's already the first time, I'm not saying yes, you need to be said. Let them be. One consideration, why would I consider? I can satisfy your lordship on that point.
Lordship, if I may, for this slightly referring regarding the seniority list. The seniority list, which is at annexure 29, vision 69. At column number, second last column, this is date of counting seniority in the present grade. In this seniority list maintained by the respondent department lordship, the 3 persons where the petitioner is saying that which are listed serial number 9, 10, 12. The seniority list, as per the list maintained by the department, they are above the petitioner. Because counting of seniority to the present grade for the petitioner, which is a serial number 6, is from 18/5/2006. And the 3 persons where the petitioner is mentioning, which serial number 9, 10, and 12. One is at 1996. Second one is 13/5/1997. And the third, Mr. Yashilamba, is 16/2/1999. They are much above as per the list maintained by them. Now, if the petitioner is aggrieved by the seniority list,
No,
is being sufficient.
this seniority list of which grade? Grade 3 or grade 2?
Yes, as well as the 3 persons, they are in the grade 3. Grade 3.
In grade
And
two,
in grade two, the petitioner, the petitioner is in grade two as well as least. However, on the basis of now lordship, there's one small point that I want to make is that the writ petition, the petitioner is here before this the court because he's aggrieved by the non-consideration of our case by the DPC. Now at the time of DPC, the vacancy was not there. Only the vacancy arose only after the DPC was concluded, that is on 7th December 2022.
is there any rule that I can opt for a particular post?
Lordship, in the prayer portion, in the prayer, in the writ petition, Lordship, if Lordship may, can the prayer portion of the writ petition?
My question is,
Lordship.
can any candidate can opt for a particular post?
Lordship, that is,
I must be promoted to this post. Is the rule provides?
Lordship, no.
No.
Here, on the promoting on the line, the next promotion is the section officer. As for the post, the present post held by the petitioner. Now, her next promotion will be in the section officer, Lordship. But that should be considered by the DPC, recommended by the DPC. Now, here, the writ petitioner is here. Even the prayer portion that he's opted for a particular post, that is a section officer, Lordship.
Documentation.
Documentation, Lordship. This is in the prayer. Very prayer of the petition is very specific that, I mean, just the highlighted portion. Directing the respondent, Lordship, that is a page number 21, the writ petition, to consider the promotion of the petitioner to the post of a section officer documentation or any other class 1 grade A post with effect from the date her junior was promoted and further to restore her seniority in the promotion grade vis-a-vis her junior with the other consequent benefits. Lordship, here the petitioner is for the next senior cadet officer cadet, that is a section officer documentation. Now her case will be considered by the DPC, but from the date where the DPC is here and her case is considered, not from the date, because at the time of the earlier DPC, as claimed by the petitioner, the vacancy was not there. So on this, if the petition is aggrieved by not considering her case by the DPC, you should have challenged that the DPC proceeding for that order.
So where is the promotion order?
And page number 43 in the petition.
40?
43.
So they've been promoted in the month of May 2020. The post is lying vacant since December 2021.
Yes, Lordship.
So her case could have been considered by the DPC.
Lordship, for considering
Why
the
her case was not considered? When the DPC sick?
DPC, the latest DPC was on 7th December 2021.
2021.
2021. DPC. Only after the DPC, the post claimed by the petitioner vacated.
It says the post was vacated in effect from 30th November. From 30th November.
Now suggest what to do? Post is lying vacant
Submission is that since the lower certain seniors are bypass, not considered. He's entitled to be considered, he or she is entitled to be considered. Can you just press 2 or 3? This was on the
2, 3. Come nearer to this microphone.
Lush.
Yes.
Can I just place certain authorities?
Okay.
Case laws, just to show that. Lordship, may kindly come to the first one, 1997, 10 SCC. 1997, 10 SCC. 694. Sorry, yeah, 616, paragraph 12. Paragraph 12. Lordship, can I just go to the relevant portion of paragraph 12 at page 624? Let's item E, my lord. Let's item E. The next below rule in the service juris, Lordship has got it. The next below rule in service jurisprudence seeks to ensure that if a junior employee is given promotion without considering his senior, then the senior employee can claim the right to be considered for such promotion with effect from the date on which the juniors was so promoted. That is. So here clearly, my lord, my juniors who are in Group C post, not even Group B, Group C. I mean Group B. Now, my lord, people who are in Group C have been directly promoted to Group A, Class 1, whereas after serving for more than 16 years, my lord, for no reasons have been ignored. And
Let the PPC first sit.
Lordship,
Then decide your.
then my
where-
lord, Lordship, just one more, my
Then
lord.
if you have been promoted, then putting this rule, file on representation to the. authority.
Lordship, can I, of this honorable court division bench case, one more, my lord. Just one direction where similarly where the person has been ignored, my lord, wrongly denied promotion, rather. 2008, 2 GLT. 492. Paragraph 12, my lord. Paragraph 12, may I just read the direction, how, because the facts are simple. Since the petitioner's case for promotion was wrongly denied, paragraph 12, my lord, page 495, was found it. Since the petitioner's case for promotion was wrongly denied at the appropriate time, and since the petitioner has been given belated, here the promotion was given, my lord. We deem it appropriate to direct holding of review DPC for giving retrospective effect to the promotion of the writ petitioner with effect from an earlier date when promotions were given to other eligible assistant engineer to the post of executive engineer on the basis of recommendation of DPC, which may also. So now, therefore, Lordship, going back, coming back, it will only create hardship. So, Lordship, in the interest of justice, since this is a settled norm, that when a person is denied, wrongly denied, then is entitled to be promoted with effect from the date on which others also got promoted. And Lordship, one more Supreme Court case, 2006 9 SCC. Here, my lord, promotion was denied based on some adverse remark, my lord, but that was expunged subsequently. Short judgment, my lord, 694, 694, my lord. Let's just read paragraph 3 and 4. Paragraph 2. The appellant was refused promotion in the year 1985 on the ground that there were certain adverse entries in his service records. Here, my lord, no, nothing. There's nothing against me. Thereafter, in the year 89, after adverse entries were expunged, his case was taken up for promotion and he was granted promotion with effect from 6/6/1989. The appellant then moved Uttar Pradesh Public Service Tribunal, and his grievance was that the only ground for refusing promotion to the appellant in the year 85 was adverse entries, and the having expunged, he should have been granted promotion with effect from 11/7/85 instead of 6/6/89, on which day his juniors were granted promotion. The tribunal dismissed the petition, and the same was confirmed by the High Court in the writ petition. Hence, is appealed by special leave. Undisputedly, the promotion of the appellant for the higher post was refused in the year 85 on the sole ground that there were certain adverse entries in his service record, and the same having been expunged, and in the year 89, he was found fit and granted promotion. The appellant junior had been granted promotion with effect from 11/7/85. In view of the fact that the adverse entries in the service records of the appellant have been expunged, we are of the view that in the year 85, promotions was wrongly refused to the appellant. As such, the state should grant him promotion with effect from the day his junior were granted promotion, that is promotion to the post of deputy collector with effect from 11/7/85. Worship, here, in spite of an expert, here there's nothing against me, yet I have totally been ignored. My Lord, yes, right to be promoted is not a fundamental right, but the right to be considered for promotion is a fundamental right. And that right has been denied to me. And therefore, my Lord, my respectful submission is that I'm entitled to be considered.
Where it is stated right to be considered is a.
Yes,
fundamental.
2007-10 SEC. 2007-10 SEC 513. Paragraph 13. Page 522. May I read it? Paragraph 13, my Lord, by page 522. Worship has found it. 522. Paragraph 13, man.
Yes.
Although a person has no fundamental right of promotion in terms of Article 16 of the Constitution of India, he has a fundamental right to be considered therefore, an effective and meaningful consideration is postulated thereby. The terms and conditions of service of an employee, including his right to be considered for promotion, indisputably are governed by rules framed under proviso appended to Article 309 of the Constitution of India. Therefore, my Lord, right to promotion, not a fundamental right, but right to be considered. And that right has to be an effective right, my Lord, a meaningful right. And when this has been denied for absolutely no reason at all, my Lord, no reason at all, not even a whisper that there's something against me. But this is the reason why I'm not. DPC, Lordship, my name is not there.
Is the DPC resolution available here?
Yes, my Lord. May I?
Page number?
First one is page number 81, my Lord. Yes, sorry. Sir? 79, my Lord. First one is 79. 79. 79. My Lord, this was the DPC that was held on 7th September 2021.
Is there any reference to the petitioner here?
Nothing, my Lord. Some 11 names were recommended. My name is not there at all. May I just read the last portion, my Lord? Chairman, second paragraph, my Lord. Chairman also pointed out that several NSCC employees have not received any promotion for the last 22 to 26 years. Also, MSCB, though granted, has not been released due to paucity of funds. The Departmental Promotion Committee, after going through the seniority list, APAR, and service records are as made available, regiments as shown below. My Lord, my name does not appear amongst the 11. I've been overlooked. What is the reason, my Lord? No reason given. Then, my Lord, kindly come to.
Which is the list that they have considered?
My Lord.
Where is the list that they have considered?
Then 81, my Lord. Page 81. Mary, the second last paragraph, my Lord. NACC has page 81, annexure 33. NACC has not yet adopted Uniform Recruitment Service Rules of ZCC 2014 and continues to follow the previous recruitment rules of NEZCC. Hence, the promotion have been examined and recommended in the light of existing staffing pattern of NACC. At the reconvened meeting held on 7th December 2021, existing staff pattern of NSCC and existing recruitment rules were placed before the committee. In accordance to the same, after going through the seniority list, upper service record and possession of vacant posts as well as resultant vacant posts due to promotion in different section under the establishment was made available by any ZCC, the committee recommends the following promotions. And 10 names, my lord. Out of the 11, 10 names have been recommended. My name is not there. No reason why I've not been considered.
No,
If-
this page number 79.
Yes, my lord. sir.
What is the difference between the 79 and 81?
My lord, these were the names who were selected and
This
for
one is
consideration.
7 September.
Yes, 7 September.
2021.
For consideration, my lord. And subsequently, recommendation was made on 7th December.
This was for first one for consideration.
Yes. Yes. And then 7 is the
Why the name
recommendation.
of the petitioner is not
Yes, that's the case, my lord. That's my case. Why?
Just the only reason was that there's an existing vacancy. There's
no,
an
no,
existing, that was the only reason that is mentioned in the
there.
recommendation.
So even that
Yes,
the
Lordship.
DPC resolution is silent about this.
Lordship.
Lordship, may I just show one more document, my lord? A meeting, page 73. My lord, the Honorable Governor is the chairman of this organization, my lord. 73, there was a meeting, minus, my lord, page 73. Meeting minutes of between the Honorable His Excellency Sri R.N. Ravi, Honorable Governor of Nagaland, and Chairman NSCC on 23rd July 2021 at
You are
Rajput.
reading page number?
73, ma'am. 73, annexure 30.
Yes.
Minutes of meeting with His Excellency Sri R.N. Ravi, Honorable Governor of Nagaland and Chairman NEZCC on 23rd July 2021 at Rajbhavan, Kohima. Lordship, may I take your Lordship to the relevant portion only, ma'am. So many other things were considered regarding promotion also was considered at page 75, ma'am.
Yes.
DPC meeting. Director requested permission of Honorable Chairman to hold a DPC meeting for several overdue promotion. As several people in the organization were working in the same post for 15 plus years and morale of the staff was low. As most of the staff had reached the higher salary level due to MSCP, the change could be in designation only. Honorable Chairman gave permission to go ahead with DPC meeting. The redesignate the deserving candidates provided there is no financial implication considering the current financial condition of any CCC. So, Lordship, I've also been serving for more than 15 years. I've also got MSCP, my Lord. Lordship, may kindly see, I've already got MSCP. So why I should be denied? I don't understand why I should have been denied, man. I've also received MSCP.
Okay.
Don't understand. Yes, please. Lordship, there are so many other case laws where junior that is there, but Lordship is satisfied, then I'll not place those men. I'm entitled to be considered with retrospective effect. The post of, now, my lord, the post of section officer documentation is lying vacant. And I'm also, my lord, discharging the duties. The duties have been given to me. It's an additional charge, my lord.
Your good name, pardon, sir?
Inti Longjam, my lord.
Inti Longjam, learned consultant of sir.
Deputy Armuli,
Government deputy.
CGC.
Learned CGC.
Josh.
That is central government.
Central government.
Yes, sir. Learned CGC for the government concluded judgment result.
Obliged, my lord.
For hearing, item number 63.
Your Lordship, the counsel for the petitioner is my friend Seth Simon. She's here, Your Lordship. She's here. She's ready for the hearing, Your Lordship.
So, okay, then let her come at 2 p.m.
Lordship, at 2, Your Lordship.
Yeah.
Unlisted motion, item number 65.
Next,
Madam,
Lordship.
have you received any instruction?
Your lordship, both the officials were out due to
Acha.
their prior engagement, your lordship, so.
So till returnable that notice be, that order be state.
Yes, Lordship. Lordship. Yes, Lordship, the provisions are very clear, Lordship. In the eviction order, there is no mention of show cause issued to the petitioner.
Or
Yeah.
Mr. Prosecutor for that, or for the also heard Miss.
It's very.
Learned counsel for the state response. In this petition under Article 226, stroke 227 of the Constitution of India, the petitioner has selects the correctness or otherwise of the order dated. The order number ZAB-1 stroke 333 stroke 14 volume 1 dated 25/6. Where is that impugn order?
Impugn order is at 24, page 24.
Dated impugn order number JLK dash sumo stroke review REB dash 8 23 232087 dated 15/11/2023 issued by the additional deputy commissioner and additional deputy commissioner Taluki Nagaland.
Jointly issued. These are jointly issued by two districts. Yes.
Jointly issued by. Mr. Hotel Learned Council for the petitioner submits that the petitioner was allotted a plot of land in which village?
Kehoi village, Lordship. In the
Kehoi village under Sumukidima district of Nagaland by the Gaugura.
By the head GB.
By the head Gaugura.
Head Gambara.
Head Gaugura. And he was in peaceful possession of the same since the year 2018.
Lordship.
And during the aforesaid period, the petitioner has developed the said plot of land and constructed his residential house. And he has been residing in the said house with his family, consisting of his wife and 3 children. Mr. Pote further submits that without any prior notice or calling for any explanation, the respondent authorities have arbitrarily and illegally issued eviction order dated 15/11/2023 without citing any provision of law or rules for such eviction in respect of the only shelter of the petitioner. And by the said impugned order, the petitioner was asked to vacate the plot of land and to remove his structure within 14 days, which will expire tomorrow. That is 29/11/2023. Referring to section 5, in bracket 1, Roman 1 of Nagaland, eviction of person in unauthorized occupation of public land, 1971. Mr. Kote submits that the said provision provides that if in respect of any public land, the deputy commissioner is of opinion that such land is in the unauthorized occupation of any person, or persons, he shall issue a notice in such form and containing such particulars as may be prescribed, calling upon all the persons concerned to show cause before such date, not being less than 15 days after the date of the notice, as may be specified in the notice, why an order under section 1 of section 6 should not be made and shall cause it to be served in the manner referred in subsection 2. Mr. Kote further submits that the aforesaid provision has not been complied with here in this case, and as such, the impugned order is arbitrary and illegal, and therefore it is content to satisfy the same. Mr. Kote further submits that the plot of land being occupied by the petitioner is not a public land but a private land of the place Gauhati. And the same was allotted to him by the HGB. Right? And on such count also the impugned order is illegal and arbitrary. On the other hand, my learned State Council submits that notice may be issued at this stage in respect of the interim care of the petitioner also. Having heard the submission of learned advocates on both sides, I have gone to the petition lesson record. And the impugned order dated 15/11/2023 and also the relevant provision of Nagaland eviction of person in unauthorized occupation of public land act 1971. It appears that the plot of land being occupied by the petitioner is a private land of Kohima place allotted to him by the HGB. Further, it appears that even if it assumed to be the public land, yet the provision of section 5 within bracket Roman 1 of the Act (1971) has not been followed here in this petition. Whereas, having considered the submission of advocates of both sides and also considering the network and further considering the relevant provision of law, This court is inclined to issue notice to the respondents returned within 4 weeks. Sleep upon respondent number.
1-6.
All the respondents.
All the-
1-6.
However, no formal notice is required to be issued as all the respondents are represented by Ms. So-and-so. As Ms. So-and-so entered appearance on behalf of all the respondents and received notice. However, extra requisite copy of the petition will furnished to her during the course of the hearing. Having considered the submission of Mr. Patel, learned counsel for the petitioner, and also considering the facts and circumstances on the record and the relevant provision of law, the impugned order dated 15/11/2023, number so and so stands state he will return a bill this after 4 weeks.
Are you blind? Lordship, I humbly request the Lordship may give the order, finish let the order be ready by today. Since eviction is closing. Lordship, highly obliged.
After half an hour, it will be available.
Lordship, highly obliged.
For hearing, item number 63.
May it please, my lord.
Yes.
Lordship, the first writ petition was 31K 2017 was dismissed, and so after the dismissal, I filed writ appeal number 1 2019, which was partially allowed. Lordship will kindly see the direction of the Honorable Division Bench. My lord will kindly come to page, the operative portion, I will read out at page 20, paragraph 14. The direction of the Honorable Court. Paragraph 14,
Yes.
page 20. 14. The
Yes, yes.
pray,
Got it.
I'll read out, Lordship. The prayer A of the writ petition relates to setting aside and quashing of the impugned letter dated 14/3/2017, bearing memo number so and so dated 14/3/2017, issued by the Undersecretary to the Government of Nagaland Works and Housing Department, whereby the name of the fourth respondent, namely Srimati Secha Pila, Lordship.
Yes. Yes.
The prayer A of the writ petition relates to setting aside and quashing of the impugned letter dated 14/3/2017, bearing number so and so, dated 14/3/2017, issued by the Undersecretary to the Government of Nagaland Works and Housing Department, whereby the name of the fourth respondent, namely Srimati Secha Pilas T. Sangtam, was approved for appointment as Chowkidar against the vacancy arising out of retirement of Sri Heshivi Chowkidar. In this connection, it is seen that the state respondent number 1, 2, 3 have not been able to demonstrate that the respondent number 4 has been appointed after following the due process of law prescribed for appointment to grade 4 post in the state of Nagaland. The respondent have not been able to show that any transparent appointment policy was followed by the respondent in the matter of public employment by issuing advertisement, inviting the eligible citizens to appear for such selection. On a perusal of the affidavit in opposition filed by the state respondent number 1, 2, and 3, as well as the affidavit in opposition filed by the respondent number 4. In connection with the writ petition, the respondent number 4 has admitted by the annexure 1 that she applied for being appointed as Chowkidar against the retirement of Sri Heshivi before the engineer-in-chief PWD, and that as per the affidavit filed by the state, the government had granted approval to the chief engineer-in-chief PNPWD by the impugned order under memo dated 14/3/2017. It is reiterated that despite service of notice, respondent number 4 has not appeared to contest this appeal. The learned government advocate has not been able to show us any recruitment rules applicable as on 14/3/2017, providing that a mere application one can be appointed in government service in grade 4, as if there is no recruitment policy in force in the matter of granting public employment. Accordingly, we are of the considered opinion that the manner in which the respondent number 4 has been appointed is not in accordance with the recruitment rules in force as on 14/3/2017, when the impugned order was passed by granting approval to the appointment of respondent number 4, as no opportunity was granted to eligible citizens to participate in the recruitment process. Hence, we are inclined to interfere with the appointment of the respondent number 4 as the Chowkidar at PWD office at Sayechong, and as such, we have no hesitation to partly allow this writ appeal insofar as it relates to prayer number A of the writ petition by setting aside and quashing the approval of appointment of Srimati Setsapila T. Sangtam as Chowkidar against vacancy arising out of retirement of Sri Heshivi Chowkidar on 31/7/2016 under Executive Engineer PWD R&B Kipri Division by the order of approval bearing memo number so and so dated 14/3/2017 issued by the Government of Nagaland Works and Housing Department Establishment Branch by the Undersecretary to the Government of Nagaland without interfering with approval granted to others named therein. The appointment of determination number 2 is answered accordingly. It is needless to say that the competent authority of the State Public Works Department would pass appropriate orders to set aside, rescind the order of appointment of the respondent number 4 to the post of Chowkidar, and that the state government would undertake a transparent, this is very crucial, Lordship, the state government would undertake a transparent means to fill up the post of Chowkidar in the establishment of Executive Engineer PWD R&B Kipri Division, so that the appellant also gets an opportunity to apply for the said post if she is otherwise eligible to apply. 15. On the terms as indicated above, this writ appeal stand partially allowed in respect of prayer A made in the writ petition. Now, what has happened is, after this, Lordship will kindly come to page.
What was prayer A?
Prayer A is to quash the appointment of the respondent number 4.
Yes.
So that is already quashed. Yes. Now,
Thereafter,
Lordship,
the petitioner was allowed to apply for the said post.
no, that's why I have filed this writ petition, because they did not, as per the direction, they did not make any advertisement, the department. They did not make any advertisement, and within 2 days, the petitioner lives in the interior Kipiri district, which takes 2 days to reach Kohima. So within 2 days, the petitioner was asked to come to the office without any advertisement. And there, when the petitioner came to the office, she was asked, what is her name? That was all. And then they appointed the respondent number, present respondent number 4. So we are challenging that that as per the direction of this honorable court, there should be an advertisement. My lord will kindly come to page 23B. This is the recent latest office memorandum that has been issued by the government of Nagaland for filling up of Group D post in the department Karijandam issued.
So when the appointment of respondent was, the appointment letter was issued,
That was, Lordship will kindly come to page. This is 18th August 2022. Page 27, annexure F.
no, respondent was appointed after this circular, after this notification. After
Yes,
this
Lordship.
memorandum.
Yes, Lordship.
Acha. So as per this memorandum.
As
they
per
are
this
bound to-
memorandum, this is for compassionate appointment in Group D post and land owner appointment. Land owner in Nagaland, that is president. There is a special privilege for, a scheme has been adopted by the state government for land owners, those who donated land to establish government offices without cost, without taking any money, and any grade 4 post, one-time appointment.
Which category the petitioner falls?
Lordship, petitioner is the land owner of the established PWD R&B Executive Engineer Office at Seichong.
And the respondent?
He is an outsider. Outsider, that is, he is not a land owner, Lordship.
Acha.
So recently, this is the latest 3rd March 2022, where filling up of D post in the departments is that where it says that this is for the land owners and the compassionate appointees. Where there is land owners and compassionate appointment, advertisement need not be necessary.
Your case is that you were the
Landowner.
And secondly, the direction given in the rate appeal
Is to make a.
not been followed by the respondent.
Yes, that is my. So after passing of this judgment order, Lordship will kindly come to page 24, annexure C. This is the direction from the government to the Engineer-in-Chief NPWD Nagaland Kohima. Lordship, type out copy is at page 24, 24A.
Yes.
Lordship, this one, this is issued by the Deputy Secretary to the Government of Nagaland. This is by the state government. To the Engineer-in-Chief NPWD Nagaland Kohima, subject, court order dated 26/11/2020, passed in writ appeal number 1K 2019, Srimati Vitoni Simi versus State of Nagaland and others. Sir, I am directed to refer to your letter number so and so dated 9/2/2021, and in view of the Honorable Court's directive. 1. Approval for appointment conveyed in respect of Srimati Setsapila T. Sangtam for appointment to the post of Chokidar under EEPWD R&B Kipiri Division by the so and so dated 14/3/2017 stands cancelled. Then number 2. This is very crucial, Lordship. You are requested to advertise the post. My Lord will kindly appreciate. You are requested to advertise the post for appointment as per the existing government guidelines. Guidelines as and when ban on appointment is lifted by the government. Ban on appointment was lifted by the government. There was a certain time where the government banned appointment.
When the ban was lifted?
Yes, Lordship, I have annex seat at page 25, annexure D. Ban was lifted on 27th May 2022. In partial modification, lifting of ban on appointment of Group D employees. This is office memorandum, Lordship. In partial modification.
Where is the appointment letter of respondent?
Lordship, lifting of ban. Then appointment order is page 27, F. F. Consequent upon the approval of government by the letter number so and so dated 10/3/2021, Sri Hotosimi, age 25 years, date of birth 5/2/1997, education qualification, class 10 passed, son of late Akahosimi of Pisami village, Kipiri district, Nagaland, is hereby appointed as Chokidar under the Executive Engineer PWD R&B, Kipiri Division. Kipiri, Vice Sri Heshivi Sema Chokidar, PIMS Code PWD 15408, retired on 31/7/2016. In the pay level so and so of the pay matrix plus all other allowances as are admissible under the rules enforced from time to time with effect from the date of joining the post. The appointees shall be on probation for 2 years. On completion of probation period, he shall be considered for service confirmation subject to fulfillment of condition prescribed in the service rules in force. He will be liable to be discharged from service if he fails to fulfill the required conditions as laid down from time to time during the period of probation. No transfer proposal shall be entertained within 3 years from the date of posting. Medical fitness certificate is.
Madam.
Yes, Lordship.
Who is for the respondent number 4?
Now.
So what is your stand?
Lordship, as per the whole letter, Lordship, maybe not to read my affidavit, Lordship.
Full letter at the number?
Page number 2.
My calling letter is page 26, next year E, in my writ petition, Lordship. I have annexed.
Yes.
Lordship, maybe allowed to read, Lordship. What's called, read from paragraph 2. That at the outset, the deponent states that the writ petition filed with a petition is not maintainable in law as in fact, the petitioner has an opportunity to file a petition inasmuch as the admittedly, the petitioner in her petition in paragraph 4 has categorically stated that the petition traveled all the way from remote village of Kipri to Kohima and appeared before the respondent on 11/8/22 and has appeared in the interview conducted by the state respondent and on being unsuccessful, has resorted to file this petition without having cause of action against the respondent. Therefore, the writ petition is likely to be dismissed with cost. Lordship, the petitioner here, she has participated in the interview conducted by the
Lordship,
state.
there was no interview and we were called. The direction of the court is very clear. That's why I'm challenging. It has to be advertised. The advertisement is, Lordship will kindly come to page 32I. This is how advertisement after the direction of the court are issued in the local dailies. 32I. There was no advertisement. The direction of the court is very clear. The manner in which they issued calling letter that was not even pasted, the notice was not even pasted in the department. How did other people came to know of it and applied? There is something very fishy. My lord will kindly appreciate that. The court directed for advertisement in a clear manner.
We were referring to page number 32.
32I. This is how, after the direction of the court, this is how advertisement are made in the local dailies, Lordship. This is from the Government of Nagaland Directorate of School Education, Nagaland, press release. Dated, this is 15 September 2021. In continuation to this office advertisement of even dated Kohima, the 10th July 2021, and in compliance to the Honorable Gauhati High Court Bench Court order in writ petition number 16K 2018, dated Kohima, the 17th March 2020, for advertisement of one primary teacher post of GPS Piro, Nagaland, B, Piro Village B, under the establishment of the Senior Sub-Divisional Education Officer WOCA, the following information are given to the candidates who had applied for the same. There shall be both written and examination consisting of 100 marks and viva voice of 15 marks. 2. Syllabus written examination shall consist of general knowledge 30 marks, general knowledge, general English 30 marks, general knowledge 30 marks, professional course 40 marks. Date of examination 25th September 2021. Venue Directorate of School Education, Nagaland, Kohima. Time 10 a.m. to 12 noon. 4. The candidates are requested to collect their admit card personally on 24 September 2021 during office working hour. Henceforth, no separate calling letter will be issued to the candidate. This is how, after the direction of the court, any department, this is how the court direction is very clear that advertisement be made. Even the state government has written to the engineer-in-chief to make advertisement. But they did not do that. The department did not do that and issued calling letter at page 26, annexure E.
No. This advertisement was published in the local dailies.
This is other sample. This is a sample. Sample as to how, after the direction of the court, this is how advertisements are made in the local dailies.
No.
That is just a sample I'm trying to impress my lord.
Aspect of the present rate.
No.
This is only
In sample in other departments, any other departments, once the issue comes before this honorable court and once the
But no such advertisement was
it was not made. That's why I am approaching. I am just on the last paragraph 14, where this honorable court has to make a transparent manner, that is to advertise the post. Even the government has instructed the engineer-in-chief to make advertisement.
Yes.
They did not make it.
No advertisement.
No advertisement.
Advertisement was given. If she has submitted, finished her submission, then your lordship, I would like to.
Then just 1 minute, lordship. Allow me to finish my. This is what they are calling advertisement. I'll bring my lordship to. Lordship, I am challenging page 28G. Notice is not an advertisement, lordship. And this notice was not when on that day, when on 11th.
Page number?
28, annexure G.
Notice.
Yes. Government of Nagaland Office of the and calling letter was sent through WhatsApp. It was not advertised to my brother-in-law's WhatsApp. No calling letter was issued to me. It was sent to my brothers-in-law's WhatsApp by the department to come day after tomorrow and come to the engineer-in-chief conference hall. That is what I got. So early in the morning on that day itself, I reached, because it takes 2 days to reach Kohima. Kipuri is in the interior part of the state, lordship. How can a notice? And on that day, after attending the conference hall interview, I went to ask for advertisement. The notice was not even put up even in the department's blackboard. And from the legal cell, they photostat this and gave me 28 annexure G. It was not even pasted on the day of the so-called interview. It was not even posted on the blackboard of the department. This I got from the establishment.
Board or notice board?
Notice board. It was not even pasted in the notice board. I have even stated in my paragraph, and it was given by the legal cell, photostated and given to me. So this is what they are saying, advertisement. Notice. This is issued on 28 July 2022. in compliance to the direction of the Honorable Court's order dated 26/11/2020, passed in writ petition number 1K 2019, Srimati Vitoni Simi versus State of Nagaland and others, and in pursuant to the direction of the
Okay, madam.
Lordship.
Yes, can we consider this as an advertisement? for the
Yes,
post?
yes, my lord.
How?
Lordship, allow me to submit then, your lordship.
Yes,
Lordship, while disposing of the writ appeal, this honorable court has passed two directions. One, to set aside and quash the appointment order of the respondent number 4.
Yes.
Two, what does the court says, if I may be allowed to
not
read?
necessary. We have already passed it.
No, your lordship, allow me, because issue of advertisement will come after reading this particular paragraph. Allow me to read, your lordship. It says, it is needless to say that the competent authority of the State Public Work Department will pass appropriate orders to set aside, rescind the order of appointment or respondent number 4 to the post of Chowkidar, and that the state government would take a transparent means to fill up the post of Chowkidar in the establishment of Executive Engineer Key Period Division, so that the appellant also get an opportunity to apply for the said post.
Yes.
The issue is, has she appeared in interview or not, your lordship?
It's
The
a
issue
question
is that-
about advertisement, then advertisement in general.
Yes.
And then I have to
No,
apply for
your
the
lordship,
post, the direction of
the
the
issue
board.
is not about advertisement. The issue is whether she has appeared in interview conducted for appointment of this post.
You cannot-
That the court has directed the state respondent to fill up by way of a transparent means.
That means advertisement.
Allow me, your lordship, to take my lordship to my affidavit.
Notice is not an advertisement. Lordship.
So the first part of the order is to quash and set aside the appointment of the private respondent number 4, your lordship. That we have done it by way of the notification.
That is not in dispute.
Yes. No, we are, what I'm trying to show is, we have complied with the order of this court.
No, that's all right.
Yes.
You have canceled the appointment of
Yes.
respondent number 4.
Yes,
There
yes.
is no dispute. She has not disputed.
Yes. No, because since there was 2 order passed, so I'm just going there.
Our board of compensation.
Yes.
The advertisement was not made.
Yes.
As directed by the board.
Yes. Okay.
And our second point is.
Yes.
that notice is not an advertisement.
Lordship, if at all, if that is so, then allow me to submit, Your lordship. We have issued a notice dated 28 July 2022, which is,
There is no dispute about issuance of notice. But whether it amounts to advertisement or not, that is the question.
lordship, if it does not amount to an advertisement, then when a calling letter was sent to her on 8th of August
It was not
2022.
given to me. It was given to others.
Allow me, Your
WhatsApp.
lordship, allow me to submit.
Okay, madam,
Yes,
please sit
yes,
down.
Lordship.
And let him complete.
Yes. Now, if this cannot be treated as an advertisement, this notice, then when a notice was calling letter was sent to her on 8th of August 2022, asking her, because it clearly says, you are requested to be present on the above mentioned date at 11 a.m. with all particulars without fail. This calling letter was for the purpose of letting her appear the interview. Page 11, annexure C of my affidavit in opposition. If I may be allowed to read, Your lordship.
Yes.
To Srimati such and such, this is the name of the petitioner. Subject, calling letter. In pursuance to the notice dated 28/7/2022. Your lordship, see, look, in pursuance to the notice dated 28/7/2022, issued by this office in compliance with the direction of this court order dated 26/11/2020, passed in read appeal 1 of 2019, and in pursuance to the direction of the government by letter dated 10/3/2021, the interview for appointment to the post of Chowkidar against Sri Heshivi Sema Chogidar, retired on 31/7/2016 under the establishment of Executive Engineer PWD Kipere Division Kipere will be conducted on 11 of August 2022 at Engineer-in-Chief MPWD Conference Hall. So this particular calling letter was issued to her in pursuance to the notice dated 28/7/2022. Now, Your Lordship, if this notice dated 28/7/2022 cannot be treated as an advertisement, why did she appear? The interview. Why didn't she challenge this notice dated 28/7/2022 and the calling letter 8 of August 2022? She has accepted this calling letter and then she appeared the interview.
Now she cannot turn around.
Now she cannot turn around. If at all she was aggrieved that the order of the court has not been complied with, then when this calling letter was issued to her in pursuance to the notification, which is an advertisement to us, she should have come to the court and challenged it. Why did she sit for the interview? Now imagine, Your Lordship, she has set the interview. Has she cleared the interview, Your Lordship? Will she still approach the court saying that, no, I am not selected as per the order of the court? Will she come and say that, Your Lordship? She has set the interview, meaning thereby she knows that the order of the court has been complied with. Had it not been, Your Lordship, she should have challenged it. Even otherwise also, Your Lordship, as I have stated, has she cleared the interview, then what happens, Your Lordship? Will she still come to the court and say, no, I'm illegally appointed because I have not been appointed as per the order passed by the division bench of this honorable court? No, Your Lordship. She will never come, meaning thereby she knows that this notice dated 28/7/2022 and the calling letter 8 of August 2022 is in accordance with the order passed by the division bench of this honorable court. Your Lordship. Then what happened, Your Lordship? After appearing the interview, Lordship may allow me to take my lord to the interview minutes, which is at page 13, annexure E. Page 13, annexure E. Lordship.
Yes.
Now this, if I may be allowed to read. My notes of interview dated 11/8/2022 for the post of Chogida under the establishment of Executive Engineer, PWD, R&B, Kohima Division, Kipere, in compliance with the directions of the Honorable Court Order dated 26/11/2020, passed in writ appeal number 1, K of 2019. Your Lordship, I'll read the para 2. Here again, as per the notice, advertisement stated above, applications were received from the following candidates, including the appellant, namely, number 1, Srimati Vitoni Sumi. This is the petitioner. So, then, Your Lordship, para 3, after receipt of the application, the department has issued calling letter to all the applicants by letter number such and such dated 8/8/2022 with direction to be present for the interview on 11/8/2022 with particulars. Number 4, that on a fixed date, that is 11/8/2022, the interview was conducted from 10 a.m. till 2 p.m. at Engineer-in-Chief PWD Conference Hall. Number 5, that on considering the overall performance of all the candidates, the interview board has opined that Sri Hotosumi, he is a private respondent in the present writ petition, Your Lordship, who is also a resident of Kipere town, where the office of the Executive Engineer PWD Kipere is located, will be the ideal choice for the post. Lordship, the next page. Para 6. Thus, the interview board has decided to appoint Sri Hotosumi to the post of Chogidar vacated on retirement of Sri Heshivis Sema Chogidar on 31/7/2016 under the establishment of Executive Engineer, Kipere Division, Kipere. Your Lordship, the issue is this: the private respondent were not appointed illegally. The department has conducted a proper interview on merit. On merit, the private respondent was appointed. The petitioner appeared the same interview without any complaint. Without any complaint. She has appeared in interview. Now, after failing terribly in the interview, she comes back and says that no, the interview process is wrong. If at all it was wrong, Your Lordship, if at all according to her it was wrong, she should have approached this court by stating that no, this is not how the interview should be conducted, and this is not in accordance with the judgment passed by this honorable court. She silently went ahead, appeared in the interview, and now comes up with a statement that I did not receive the calling letter. This is not a notice. I was received the calling letter from WhatsApp. That is not the issue. The issue is whether she has appeared in the interview or not, Your Lordship. She has already appeared in the interview.
So your case is that having participated in the
Yes.
interview?
Yes. Allow me to place a judgment on that, Your Lordship.
Yes.
1995. 3 SSC, 486, Your Lordship. I'll straight away take my Lordship to the relevant para.
Yes.
Page 493, Your Lordship. Para 9. Para 9.
Yes.
I may be allowed to read, Your Lordship. Before dealing with this contention, we must keep in view the silent facts that the petitioner as well as the contesting successful candidates being respondent concerned herein were all found eligible in the light of the marks obtained in the written test to be eligible to be called for oral interview. Up to this stage, there was no dispute between the parties. The petitioner also appeared at the oral interview conducted by the members concerned of the commission who interviewed the petitioner as well as the contesting respondent concerned. Thus, the petitioner took a chance to get themselves selected at the said oral interview, only because they did not find themselves to have emerged successful as a result of their combined performance, both at the written and the oral interview. They have filed this writ petition. It is now well settled that if a candidate takes a calculated chance and appeared at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of the interview was unfair or the selection committee was not properly constituted. In the case of Om Prakash Shukla versus Akhilesh Kumar Shukla, it has been clearly laid down by the bench of 3 learned judges of this court that when a petitioner appeared at the examination without protest, and when he found that he could not succeed in examination, he filed a petition challenging the said examination. The High Court should not have granted any relief to such a petitioner. This is exactly the case here, Your Lordship. She suddenly appeared in the interview, failed terribly in the interview. Now she is coming and challenging the selection process, Your Lordship. The writ petition is liable to be dismissed, Your Lordship.
Yes, Mr. Kotek.
Lordship, I endorse this submission of the learned government.
Yes, Madam, any reply?
Lordship, just what the learned government advocate has submitted the citation, there will be an advertisement. I haven't seen it, but it is an advertisement where candidates in the market applied for it, and after appearing, they might have approached the court. Here, there is a judgment order of writ appeal. The direction of the court is very clear. Just the learned government advocate show the law where notice is an advertisement. Show the law. Show the law before this honorable court that notice is an advertisement. And Lordship, when the notice was not even pasted in the establishment of the department, where did this, and I don't know. I was the concerned person. I was asked to apply for the post. The direction of the court is very clear. That is on advertisement. How did this 1, 2, 3, 4, 5, when it was not even posted? That's why I'm saying that the manner in which this interview was conducted by showing and notice, that was not even posted. There are some people
there are some people who works in the NPWD. They were asked to, they used to verify the blackboard. It was not even pasted, and this, how did this 1, 2, 3, 4, 5 other person applied for it when it was not even pasted? It is fishy. It is illegal. There is something fishy, Lordship. The manner in which this interview was conducted is fishy. I was not even given a time to, on 11th, I reached Kohima in the morning by night bus, Lordship. Look at the direction of this Honorable Court. Where is the transparency? These 5, they have stated that they have applied. Where did they come to know of it? When notice was given by the office? Notice, advertisement has to call all the eligible candidates. Eligible candidates notice. Advertisement. So the advertisement, I have shown the sample. This is how advertisements are made after the direction of the court. And this is another department. So where is the advertisement? If the learned government advocate and the private respondent can show before this honorable court that notice is an advertisement, then that is one thing. Notice is never an advertisement. Advertisement notice is given in a manner designed to attract public attention. Where is the question of public attention here? Information communicated to the public by newspaper, radio is called an advertisement, Lordship.
According to you, the vaccine certificate case, that part by candidate
No, Lordship. It was a public advertisement. And
there was an advertisement.
yeah, advertisement.
In your case,
There was no advertisement. And there is a direction of the court. So the direction of the court in paragraph 14 is very clear. How in a manner, in that manner, if they want to do like this, why should they, this honorable division bench quash the appointment order of the respondent number 4? There was no advertisement.
That's all right. Then instead of selecting the piece, why did you participate in the
Lordship, I was asked, see, this is a grade 4 post. This is a grade 4 post, and education is only, qualification is only, I was asked to come to the office. And this calling letter was not even served to me. That is one aspect, Lordship. I said that this calling letter was not even served to me. It was sent, this calling letter was Lordship, here I'm not seeking for my, here in this manner, in this matter, I'm not seeking for my own, I am the landowner. Even the deputy commissioner has already certified that I am the landowner. This is something very absurd, where the first writ petition was dismissed because we went for appeal, but the first writ petition was dismissed. I am the landowner. That is an admitted fact. I am the landowner who donated the land and establishment. That is the factual position till date. And if I want to close down the office, that also I can do. Being a landowner, I have not been given even one-time appointment, because landowner donation always carries one-time appointment of grade 4 post and contractual works to the landowners. Why this was dismissed is that the learned single judge held that my husband, we are the landowners. But unfortunately, it is held that I am the wife. My husband is the landowner, I am the wife, where the husband and wife has been segregated, where it is said, I don't have the locus standi. Lordship, if approaching the court became more complicated than when I did not approach the court. Frank, this is a factual position. As a wife, I have no locus standi. Then the land belongs to the children, to my family. So where is the question of husband and
No, that was like the.
Yes. So the factual matrix is that I am the landowner till date. And if I want to If I want to close down the office, I am the landowner, I was not provided any one-time landowner appointment. So that is another question in writ petition, in the writ petition, so I wouldn't touch this. I am just praying that whatever they have been submitting is that the fact of the case differs from one case to the other. Here, the direction of the court, if there be no direction of the court, that is another thing, but the direction of the court is for advertisement. And when notice is not an advertisement, I was asked to come to the office, and then that is how the manner in which this was conducted, that is all, Lordship. So my simple case is that make general advertisement as per law, as per the direction of this court. I will also apply. I was also given the opportunity to apply. I did not apply for it, Lordship. So it has, this honorable court has to abide, to go by the direction of this honorable court division bench, Lordship. It is very clear. So I'm just seeking for, they have issued office memorandum 3rd March 2022. And if the basis, Lordship, if the basis, that is just a notice, if a notice is issued and whether I attend the interview or no interview, Lordship, the basis itself is illegal. It is not as per the direction of this honorable court. So what I'm praying before this honorable court is issue general advertisement. As per the direction of the court, it is very clear. The last page, my lord, is already conversant with it. I will also apply. Any other candidate can also apply, and then let there be general advertisement. There is no advertisement, Lordship. The manner in which this interview was conducted is very fishy, Lordship. I cannot bring out the whole thing, but I may not, before this honorable court, I may not say adverse things with due respect before this honorable court and all, but what the interview was conducted is not proper. It's improper, Lordship. So let there be general advertisement as per the direction of this honorable court, so that all other candidates, there won't be only 4 or 5 pick and choose candidates who will apply. Who told them to apply? When it was not even pasted in the blackboard. I got this notice from the legal section, Lordship. That is a fact. There is something fishy.
Lordship, just a short submission on that. The Lordship will appreciate the fact that this division bench of this court has directed the department to give an opportunity also to the petitioner to apply for the post. The
I did
petitioner
not apply. I did not apply. Where
And
is
appeared in
my
interview.
application? Where is my application? We are on that. I did not apply. I was not given the opportunity
Had
to
she not
apply.
applied, why, how comes a calling letter was sent in her name?
That is because of the illegality of the department.
Lordship, she cannot say that.
Then the government has directed for advertisement of the post. I have already read out, Lordship, at page 24 annexure C.
The rest, your Lordship has already understood the matters. I leave it to my Lord, your Lordship.
Yes,
However,
yes. I also
she
leave
has
it to the
appeared the
understanding
interview,
of my
Lordship. She has
Lordship.
appeared the interview. That is a fact of the case.
The government has also specifically, you are requested to advertise the post. On 16th March 2021, government of Nagaland wrote to the engineer-in-chief why she issued notice that was not even pasted in the department and conducted this. My lord will kind of page 24, annexure C. Yes, Lordship, Lordship. Illegality will multiply, Lordship.
Yeah, please. Lordship, if I
Lordship.
may, Lordship.
Obliged,
Lordship, if I may, Lordship.
Yes.
One sentence. Lordship, I, being the respondent before, I have seen notice and I've applied, and accordingly I was given the calling letter and accordingly I appear for the interview. So also the petitioner, she appeared for the interview. Both of us, in fact, all six of us, we faced the interview. And on being unsuccessful, the petitioner is before the Honorable Court. And I've been successful, the department has selected me.
I did not see the notice. There was no general advertisement.
If the landowners have been given preferential treatment, then why she was not given the preferential treatment?
The landowners, no, your lordship.
That's why.
Landowner- The landowner issue is already settled. She has miserably failed to claim landowner, to show that she is a landowner. In the judgment, your lordship, allow me to take my lordship to para 9 of the order. Para 9 of the order, your lordship. Page 17. Yes, of the writ appeal, which is annexed as annexure, page 17 of the writ petition, your lordship.
Yes.
Yes, your lordship, if I may be allowed to read this para 9.
Yes.
Moreover, there is no positive statement as to whether the appellant father-in-law is alive or not. There is also no positive statement as to whether the appellant father-in-law applied for the appointment of any grade 4 post upon establishment of the PWD office on his purported donated land. It has also seen in the writ petition that there is no statement regarding the exact date on which the appellant got married and became a member of the family members of her father-in-law.
Oh my God.
As per her statement made in the writ petition, the appellant claims to be the landowners of the existing PWD office Yochang. The appellant has not disclosed the name of her father-in-law in the writ petition. However, from annexure B to the writ petition, which is the applications for the post of Chokidar, it appears that the application has been made in the name of Vitoni Sumi, father's name Sheikh Hughie Sumi, date of birth 3/5/1994. However, in the said application, the name of the father-in-law of the appellant is not disclosed, but yet the applications claim to be the landowner. As per annexure C to the writ petition, the chairman of such and such council has certified on 25/5/2016 that one Sri such and such is the landowner of PWD office as Sayuchang, and they have recommended Mrs. Vitoni, wife of such and such, to be entitled to grade 4 in PWD appointment at Sayuchang. Similarly, as per annexure C2 to the writ petition, the additional deputy commissioner Sayuchang has certified that Sri such and such is the landowner, and the Srimati such and such is the wife of Sri Hokato Yaptomi. Therefore, as per the document, the appellant has used 3 names. One, Vitoni Sumi, Mrs. Vitoni S. Yapto, and Srimati Vitoni Yaptomi. And there is no document on record to suggest that the 3 names are of the same and one person. Moreover, though the appellant claims to be the landowner as per annexure B to the writ petition, but the land ownership certificate as per annexure C, C1, and C2 to the writ petition are in favor of Sukato Yepto, and Sukato Yeptomi. There is no explanation in the writ petition that how the land ownership right has devolved on the appellant during the lifetime of her father-in-law as well as her own husband. The existence of customary right of the daughter-in-law inheriting the land of the father-in-law during his lifetime and during the lifetime of her husband has neither been pleaded nor demonstrated in the course of hearing. Your Lordship, this is important. Therefore, although it is quite plausible that the appellant may be a family member of her father-in-law, but she has miserably failed to establish that she is a landowner. Moreover, as there is no dispute that the land over which the PWD office as such was donated in 1970, as there has been a valid transfer of land in favor of state PWD. Therefore, while the concerned authorities may validly certify as to who was the erstwhile landowner prior to the donation of the land, but we are unable to accept the certificate of an annexure C, C1, and C2 to the writ petition as a valid proof of the person named therein as a landowner on the S on date to whom when those certificate was issued. Therefore, the said document failed to prove the status of the appellant as a landowner because annexure C, C1, C2 apparently contrary to the undisputed facts that the land in question has been donated to state PWD in 1970. As such, the title over the state land cannot remain in the name of any family members of the landowners who have actually donated the land. So the issue of land ownership has already been decided, Your Lordship.
Lordship, just my final conclusion, page 33, annexure J. This is issued by in Nagaland, Additional Deputy Commissioner is the authority to certify who is the landowner, and just basing upon that, landowner appointments are given. And next year, J is the Additional Deputy Commissioner Seichong, Nagaland. Sukata Yapthomi is the petitioner's husband. It is very unfortunate, I have already stated. A husband's land does not belong to the wife is also one of its kind in this case. Lordship, that is a factual position.
No, whether this document was placed before that.
Yes. But I'm just referring, since he is referring it, and today, even today, if the police can arrest us, that is one thing. But PWD office, that is our land, so we can just close it. That is how landowner, if landowner appointment are not given, even that is compelled to do. And in some cases, that is already there. And village council is the head authority. So annexure K, page 34. These two are the valid documents.
That was a finding of division.
Yes, that is unfortunate. Yes, Lordship, I admit, it's not within this subject, but just trying to relate the factual. So that's why if I am the landowner and my landowner right has been extinguished by the division bench, I'm just seeking for only the direction for general advertisement. So at least allow me to apply to it, and the rest is finished. That's all, my lord. Obliged, Lordship.